Okay, this is the first time this is being used. I just got it. I can stop using my Health and Human Services gavel. Wow, that was pretty cool. Open the executive session, and we will open with House Bill 218. You may know how expert our committee researcher is in researching things. What I discovered this morning is she is a heavy equipment repair person. I single-handedly watched her fix the huge photocopier upstairs, which prints on both sides, staples, and makes coffee simultaneously. And so because of that, we have lots of paper to hand out. This is an amendment. Representative Bernardi has offered in the place of the Bill 218, 3, 4, 5, and take a read. I will be presenting the amendment for consideration as we go to exec the bill. So take a read of 218. Some folks have found it helpful when doing so to do what we call a side-by-side, put the original bill on one side and the amendment on the other to see where they differ. The amendment does not differ that much, but rather than just say change line 22 to read this, the entire bill is reprinted, amended to be the amendment. I promised the members who are absent that we would not have fun in their absence. So, have fun quietly, please.
It's hand lotion and it smells really nice. We're the rowdy section over here.
Representative Bernardi's bill. And I have I put a copy right in front of DC. And you'll see there's a few changes that we discussed. There were two particular places in the room that tried to break out into levity, and pursuant to your comment about having fun while you were away, I quieted them down.
Good job.
All right, the chair assumes that we've all had a chance to read the amendment. You will see different things that have been changed and different things that are added. And the chair will entertain a motion on House Bill 218 as amended. The chair will move ought to pass with the amendment 218. That puts us now into discussion, and so the bill is 218. We will be voting on the amendment in a few minutes. So discussion. Representative Moulton, the others are back, so you can be funny if you wish.
Thank you, Mr. Chairman. I have problems with this bill, that it says that the personal transcript is admissible in court because there's not a way to prove its accuracy. I think that it is demeaning to the court transcriptors that we would question what they are transcribing as, you know, what that's their professional job. Anybody has the right to, my opinion is that anybody has the right to make their own documentation, but for it to be admissible in court is a problem for me.
Besides being a heavy equipment repair person, the committee researcher reminded me that the motion I made needs a second. And so I made the motion ought to pass with the amendment 218. Do we have a second to that?
I'll second.
Okay, Representative,
Clarification, if I,
you may, before
do we need a motion on the amendment first?
yes,
So that's what this, that's what
that's
your
what this
motion is?
motion.
Okay,
motion
it's on the
is.
amendment.
Thank you.
Yep.
And Representative DeSimone seconded the motion on the amendment to the bill. Further discussion. Representative Raymond.
Thank you, Mr. Chairman. So I went through this amendment line by line, and I just want to extend my appreciation to Representative Bernardi for listening to our questions last time and coming back with some changes based on that discussion. I thought that was really helpful. Having said that, I still don't think we're there, and I have some further concerns about how this will affect family court. We still have not changed anything regarding whether or not this applies to every case that's heard in family court or if it's only specific cases like divorces or child support or other things. So as stands, this includes juvenile justice cases. This includes DCYF cases. This includes any case that is being heard in family court that anyone could now make their own personal recording of. Under item 3, which is line 26, I have a note to myself. It says to protect the privacy rights of minors, the quote, personal recording of abusive or adverse treatment of any minor shall not be distributed or publicized in any manner. I thank Representative Bernardi for putting language in there because that was one of my main concerns, was protecting the privacy of children in this state. However, personal recording of abusive or adverse treatment, that language is insufficient in that no one's being abused or mistreated in the courtroom, well, one would hope, without a bailiff or someone intervening. My concern is the testimony that is being offered in court, not the actual abuse itself being publicized. So I need something in there that would say no testimony given by or in regards to mistreatment of minors shall be publicized in any way. I also want something in there that says something about we're not going to publicize or share the identities or personal information of any minors involved in court cases. I include DCYF and juvenile justice in this. These are children who have run afoul of the system, and they don't deserve to have their names out there on social media or out on the newspaper or television. It's simply unfair to them. They deserve the opportunity to grow, even if they have made mistakes and are in the juvenile justice system. That's why we seal records of minors. The last issue I have on this one is Article 4, which is also new. And it says the court shall supply all parties a digital copy of the official court recording at no cost in a timely manner. I'm thrilled with working on the cost, because this chart that we got last time that shows how insanely expensive this is highly concerning. Having said that, what does that mean, a digital copy? Does that mean an MP3, a CD, a WAV file? How do we know whether or not people are able to access that? I know, as you all know, I had brain surgery this year. All my brain scans are now on CD, which I don't have the technology to access because it's obsolete. I don't have a computer I could put that in and see. And so this is one of my big issues that I took up with my neurologist. Like, you're gonna have to print it out because I can't access this. So as it is, I will be voting against OTP.
Thank you, Representative Raymond. Anyone else?
Yeah.
Representative Bickford.
Thank you, Mr. Chairman. My concern is more in the first section, which talks about shall not waive a family court rule. And I think they need that and should have that ability to waive. I'm on a planning board and on a zoning board, and we have the ability to waive rules all the time, and it's important and very helpful to the I want to say client or the parties in the case. So I couldn't support it for that more than anything. And the transcripts thing is I agree, not quite there. I'm not against doing additional transcripts. It's just that it could be cleaned up a little more, but definitely against the not allowing the court to waive rules. I'm surprised we even have the authority to do that.
Representative Bickford, I just discovered from my primary care doctor I have water in my right ear, which is why I have been mishearing things. They're supposed to drain me on Thursday, but as a result, I did not hear exactly what you said. You are for or you are against? You could or you could not support?
Could not.
Could not. Thank you, sir.
The first paragraph in particular on the waiver issue. Thank you.
Anyone else? The motion before us is on the amendment 0276 to House Bill 218. Moved by the chair, seconded by Representative DeSimone. Would the clerk, this is on the amendment. We will then vote what we wish to do on the bill, either amended or unamended. Would the clerk please call the roll?
Chairman Pearson,
Yes.
Representative Long,
No.
Representative DeSimone,
Yes.
Representative Bickford,
No.
Representative Nelson,
Yes.
Representative McMahon,
Yes.
Representative Ball,
Yes.
Representative Panic,
Yes.
Representative Seidel,
Yes.
Representative Grossman,
No.
Representative Levesque,
No.
Representative Petrina will be voting no. Representative Perez,
No.
Representative Gregg,
No.
Representative Moulton,
No.
Representative Raymond,
No.
we have 9 no and 6 yay. So it fails.
Do you have 6 or
7. 7.
The motion fails 9-7. The chair will entertain,
It was 6. That'd be 6, wouldn't it? I mean, because it was ought to pass, so your yes comes first.
I apologize. We have 7 yay and 9 nay.
Yeah.
the chair will entertain a motion on House Bill 218 without the amendment. This is on the original bill. Representative Raymond.
I'll move ITP, please. ITL. I don't know where P came from. It's morning. ITL. Thank you.
I'll second that, Beckford.
And that was seconded by Representative Bickford. Thank you, sir. The motion is ITL. If you want the bill to fail, you vote yes. If you want the bill to pass, you vote no. On House Bill 218 FN, unamended. The chair will please, no, he won't. What do you do? Oh, the clerk, thank you. The clerk will please call the roll.
Chairman Pearson,
Yes.
Representative Long,
Yes.
Representative DeSimone,
Yes.
Representative Bickford,
Oh,
Representative.
excuse me?
You may reconsider your vote if you wish.
Yes.
Yes means no here.
No.
Okay.
Means yes.
That means yes.
Representative Nelson,
Yes.
Representative McMahon. Yes. Representative Ball,
Yes.
Representative Panic,
Yes.
Representative Seidel,
Yes.
Representative Grossman,
Yes.
Representative Levesque,
Yes.
Representative Petrina will be voting yes. Representative Perez,
Yes.
Representative Gregg,
Yes.
Representative Moulton,
Yes.
Representative Raymond.
Yes.
ITL passes 16-0.
It could be argued, well, it could be argued a lot of things. Does anybody object to this going on to consent? Seeing no objection, the bill fails. My thoughts is there's some good thoughts in here, but it's not ready, and maybe another time. So, 16-0 on to consent. Who would like to write the committee report, Representative Raymond?
It sounds like I'm being voluntold, and that is fine. If you can pass down the paper, I will
Voluntold.
I will happily do that.
Are you fine with that?
Yeah.
Okay. Before we move on to the next bill to exec, we've heard from leadership that there has been way too much food and drink brought into the committee room, and that's not just on the part of the committee, but it's on the part of the guests. All you may have in these rooms is water. So I'll be repeating that again and again. Um, as long as I keep this in my mouth, cough drops can be had, medicines can be had. You know what I mean, food and beverage. Next item is 108, and we have,
Mr.
And-
Chairman, can I ask you a quick
you
question?
may.
Can I'm allowed to, this is, to control my sugar is water with lemon. It's not a drink. I'm not allowed to have this. It's water with lemon.
You may have that,
Thank you.
Representative. I think that's fine.
Thanks.
I know you'll be careful with it.
Yeah.
That means we can have it too. Good. Going to be passing around. You may have seen this before or not. This is on 108. This has to do with penalties for making a false report. Let's see, 5, 6, 7. Remember, we discussed that and we didn't know whether other states did this or not. And although just because another state does something doesn't make it right, what we have here is a 50-state survey of what happens when people make false reports. And I'll give us about 5 minutes to look through this. This should say something perhaps as we go to deliberate. The old little boy who cried wolf so many times that when a wolf finally showed up, nobody believed him. False reports are bad. So anyway, take a look.
Mr. Chairman?
Yes.
Hi. My stepmother happens to be a social worker, and she can verify that in the state of Pennsylvania that there are plenty of people that make false reports. Now, I didn't ask her what the penalties are there. I mean, that'll be in here, right? But I can tell you from her experience that there are definitely people that make false reports. So
Okay, take a look through this. Take some time and The chair will entertain a motion on House Bill 108.
I will offer
Representative Bickford.
inexpedient to legislate. And if I may speak to my motion.
You may speak to your motion.
Thank you, Mr. Chairman. I weighed this heavily, and I would like to see something of this nature. However, I was here when Mary Stuart Guile was the chairman of our committee and brought forward these child abuse legislation, and it was during a period of time when the Roman Catholic Church was being exposed for many child abuse actions. And my fear, and her fear, was that if we take this route, that it will have a chilling effect upon those that could and should make reports, but would be in fear of being seen as doing it maliciously. And what we wanted was the people to be able to be free to speak up. Thank you.
Representative Moulton.
Thank you, Mr. Chairman. I spoke with the bill sponsor to this, and it happened this fall, and I've had extensive conversations with him, and it was via email. He said that the intention of the bill is to not discourage anonymous reporting. So in other words, you can still make an anonymous report, but they encourage you to give your information, but you still don't have to. So I think if someone is making a report in good faith, they could still give their information or not. There's always going to be an element of people who might be intimidated to make a report. But if you suspect, you know, a lot of people are mandatory reporters. I'm a mandatory reporter as well. And all you need is a suspicion in good faith to make a report. And this bill, the intention of it is only to prosecute people making malicious reports in bad faith. And so the impetus is to prove that there's bad faith, but you're also innocent until proven guilty. So I don't suspect that this bill is going to cause there to be I don't know the word I'm looking for, but a lot of people to be found that they were making a report in bad faith. But I do think that the people that, because there are bad people out there that will make a report in bad faith, I do think there should be consequences for that. Thank you.
Thank you. Anyone else?
I will wait.
Let's
nobody
go
else.
round one first. And the chair would like to point out that on the first page of the bill, one of the changes he's made is reports made to the department may, not must, may include the name, address, or phone number of the person or persons making the report. On the second page, there is a whole paragraph on anyone participating in good faith. I am a mandatory reporter as well, and I once made a report and I wasn't sure. I said, I think this is what's going on. Don't send the army. Check it out. I may be wrong. They later got back to me and said, here's what really happened. I said, thank you. I made that in good faith. I was not punished for that. We're talking about the ones who are weaponizing this, who will call up and say that single mom is doing such and such, and call again and call again. And it is not true. It is weaponized. These are the people I think this bill is trying to address. For the record, this bill passed the House last year. It sat in the Senate. Remember COVID? A lot of things sat in a lot of places and never got finished. So this bill passed last year. We're bringing it back. Any further comments? Yes, Representative Raymond.
Thank you, Mr. Chairman. So, as many of you know, I worked for DCYF here for many years. Prior to that, I worked in New York State for Child Protective Services there, which is the same thing. And in both states, I provided training to mandated reporters on when and how to call the hotline to report abuse or neglect. And in general, the advice that we give people or gave people regarding when to call was, if you're worried, call and let DCYF or CPS figure it out. Don't you try and figure it out on your own. If you're worried, just call, and they'll screen it out at the main office, at the hotline office, or they'll screen it out when the worker goes out there. The workers are trained to try and make it as least traumatizing to families as possible. Having said that, I have also worked on many, many cases where there is domestic violence within a family system. And it is very common for someone to try to utilize DCYF to harass their ex-partner or their current partner, or their child's partner because they believe one side of it. It's unfortunate. It's awful. I've worked in a state where they had this law, and I've seen the law applied twice in the 5 years that I worked there. That was it. Twice where someone was actually reported for false reporting. And I've only seen the charges stick one time. I'll be honest, this one really, it's difficult for me to decide because I want people to call DCYF. We don't want to have more kids who are missing or hurt and no one's doing anything. People need to call. Having said that, I also feel for domestic violence victims who have DCYF out in their home like 3 times a month because somebody keeps calling on them. So, I can see where this having consequences, or even just being able to say to someone, there's consequences if you continue this behavior of calling them in falsely. DCYF still has to investigate everything. Whether someone lies when they call in or are using it manipulatively, the workers still have to go out with a clean, fresh brain and try and be objective about the situation. So I worry about the effect, but I also see that 49 other states and DC and 5 territories have this, a similar version of this bill. So New Hampshire is a standout.
Representative DeSimone.
Thank you, Mr. Chairman. Considering the fact that every person, every adult in the state of New Hampshire is a mandated reporter, considering that, we must remember that all of those mandated reporters in this state have not received training. So the statement of, if you see it, it concerns you, call. Those are not the calls that this bill is concerning. If an adult in this state sees that, and I think it was used in testimony, a child goes to the bus stop on a rainy day without a coat, and then the next day it's still raining and that child still has a coat, doesn't have a coat, and then something else happens and something else happens, that may be considered to some as child abuse, and they're going to call, and they should call. However, it's the concern for the child, it's not malicious. On the other hand, as was just stated, you have somebody who's angry at another person, and they call, and again and again and again, and that is malicious. That's why we train the operators who are receiving those calls to try to differentiate the difference, and that's when they will send a caseworker out. They don't send caseworkers out for every single case. So to protect the people who are doing no wrong, I think this bill makes sense. And this state should have a bill like this in law, like most other states do. Thank you.
Representative Panic.
I'd like to share a personal experience. My son was involved in a child custody case about 5 years ago. And during the time frame that the case was going to be determined, where the child would be living, the mother had moved out of state. The judge had ruled that my son should have custody of his son. Well, that put the mother in a tailspin. And what she did is call the police and put a report in that my son made a threat to her life, which he did not. The police broke down my son's house, the door, and took my grandson away. That traumatized the child. It took 2 years of therapy to get him back on track. And it took a lot of forgiveness in my heart to forgive the mother for what she's done. But people do desperate things when you're in a child custody battle. And this would protect fathers who are in the same situation that my son was in. All right. And I think this is really an important bill to pass. Thank you.
Any further comments? We'll go to round two. Representative Bickford.
Thank you, Mr. Chairman. I don't disagree with any of these things, but what we can't measure, or is difficult to measure, is the fact it's going to have a chilling effect. I know if this passes, I'm going to think long and hard before I take a chance on the system coming by and arresting me for acting maliciously, particularly if it was, well, I wouldn't have a custody case, but anybody that does could be deemed as being malicious. And I think the division, DCYF, has got a big task on their hands, but I think they're the right people to decide to do the balance. And I just, if you ever had to defend yourself in court, it's expensive and it's scary. And that's what could happen to somebody that does make a call on their neighbor or whatever.
Representative Perez.
Yeah, for me, I will not support this bill. To be honest, as someone who is a survivor of domestic violence, this bill concerns me a lot. Especially when the person who is pushing you to the limit is someone who's telling you, if you do a report, if you call, you're going to get sent back to your country where you came from, and you're not going to be able to see your kids. This is, it scares me for victims like myself. Yeah. And especially, like I say, if immigration is involved, immigration cases, people can, take it the wrong way. So for that reason, I will not support 108.
Thank you. Thank you. Representative Ball.
Thank you, Mr. Chairman. I would just like to comment that I'm concerned, that I'm hearing more concern about the person making the report than the child whose family is going to get involved in an unfounded claim. That puts a tremendous stress on the family and the child through all the interviews and everything that they have to go through. And I'm afraid we're putting more emphasis on the person worrying about they may not report. Malicious means you'd have to be doing it. It, to me, seems like it would be so obvious, like you're doing it repeatedly, or it's so unfounded, or you can see that there's an intent behind it. If it's a goodwill and you just say, look, I'm just watching out for the child, that's seen. I think it's easy to see the difference between one and the other. My concern is more for the child and the family being put through this traumatic experience over and over and over again unnecessarily. I will support this bill.
Anyone else? Seeing none, I'll call the question. The motion is inexpedient to legislate on House Bill 108. An act relative to confidentiality of reports made to the Division of Children, Youth, and Families. As has been noted, there's nothing in the bill that relates to the rest of the title of the bill. So that's what we've got. It's inexpedient to legislate. If you want to kill the bill, you vote yes. If you want a second motion to approve the bill, you vote no. The clerk may call the roll. You got it right? I mean, this is no means yes and yes means no. The bill was seconded by Representative Long. Thank you for
Yes.
that catch.
I
I
do
got it
have
right this
down.
time. All right, the clerk may call the roll. Thank you.
Chairman Pearson,
Let's see, ITL. No.
Vice Chairman Long,
Yes.
Representative DeSimone,
No.
Representative Bickford, Representative Nelson,
No.
Representative McMahon,
No.
Representative Ball, no. Representative Panic,
No.
Representative Seidel,
No.
Representative Grossman,
Yes.
Representative Levesque,
Yes.
Representative Petrino.
Yes.
Petrino,
Virginia.
sorry. Representative Perez,
Yes.
Representative Gregg,
Yes. I got confused.
Representative Moulton,
No.
Representative Raymond,
Yes.
It is 8-8. Therefore, this motion fails. Another motion may be made.
Mr. Chairman, I would like to make a motion of ought to pass.
The motion by Representative DeSimone is ought to pass. Do I have a second?
I second it.
Hand? Representative Panic, thank you. If you're for the bill, it is now yes. If you're against the bill, it is now no.
Representative, I'm sorry,
The
Chairman,
clerk may call the roll.
I'm sorry.
That's
excuse
all
me.
right.
Chairman Pearson,
Yes.
Vice Chairman Long,
No.
Representative DeSimone,
Yes.
Representative Bickford,
No.
Representative Nelson,
Yes.
Representative McMahon,
Yes.
Representative Ball, yes. Representative Panic,
Yes.
Representative Seidel,
Yes.
Representative Grossman,
No.
Representative Levesque,
No.
Representative Petrino,
No.
Representative Perez,
No.
Representative Gregg,
No.
Representative Moulton,
Yes.
Representative Raymond,
Yes.
and the 9-8,
It can't be.
9-7, I'm sorry. I did
9
that
to
again.
7, it passes.
doing
The
that every
motion
time.
passes 9 to 7.
You need to write it down.
I will write the committee report. And
Thank you, Mr. Chair.
You're welcome. The minority reports, it is not the job or the task of the chair to figure that out, but among yourselves during a break, you may designate who will do that. We'll do that this morning. I used to work to get that done, and I was told not to do that, so I can't do that. But somebody very similar to Representative Long is acceptable. Who am I to say no?
Oh, no, I'm not accepting. There may not be a minority report. There may just be a debate on the floor. So I don't know, is there, somebody wants to write a minority?
I'll give you a few minutes to figure it out.
Seeing none,
Go ahead.
there won't be a minority report. We'll just,
Just raise his hand.
oh, do you want it? Okay, okay. Thank you.
Okay, see, that way I didn't order.
Mr. Chairman, can this go on the regular calendar and not the? Okay, okay.
For new folks, well, you're not new folks, but new folks to this committee, usually consent is unanimous or only one against everybody else. If it has a financial note, it cannot be on consent. It has to go off to finance anyway. It cannot be on consent. If there's more than 2 votes against everybody else, it doesn't go on consent. All right.
I'm slowly figuring it all out.
Going to pass around now some summary statements on the next bill we're going to exec, 126, 3, 4, 5, 6. And you will see I even have a few notes on it, which I didn't erase before I handed it to the photocopying department, and that's okay. Representative Spillane obviously likes the bill because he put it in, but he says he doesn't mind if we retain or dispose of it. This is the bill that wants to have the option of payments being on the 1st or the 15th. You will see in the handout that you are getting, there's not much out there for what other states have done on this. You'll see that on the last page. And even the 2 states that have done a little bit about it, they haven't done much either. So anyway, take a look at this. See what you think. Chair will entertain a motion on House Bill 126, an act relative to choosing the accrual date for child support payments. I have never been in a shyer committee than this one. Wow. I'm not complaining, I'm just observing.
can we just discuss it then, beforehand?
We really technically need a motion, but I never usually observe that, do I? Mostly.
Do you want a motion at least for the sake of discussion? Yes.
Yes.
Then I'll make a motion. Let's start with the positive one. Let's start with the OTP motion for the sake of discussion.
Thank you, Representative Raymond. Is there a second?
I'll second that.
Representative Moulton, let's discuss.
Mr. Chairman.
Representative Moulton.
Thank you, Mr. Chairman. There's a lot of people in this country who are living paycheck to paycheck. And I think that by putting, this is a harmless bill in my view, because
A what,
they're
Bill? Sorry, a hard block?
harmless.
Harmless, thank you.
Yep, harmless bill, in my opinion, because we're just choosing if they're paying it the 1st or the 15th of the month. So they're still being paid. So, but by putting the ball in their court, they can, families can budget better. There's a lot of stuff that comes due at the beginning of the month, like mortgages, rents, things like that. So by putting, another bill later in the month, for some people that might work for them, because if people are living paycheck to paycheck, they might need to do that. So I just don't see any negative effects of this bill. So thank you, Mr. Chairman.
Thank you, Representative. Representative Nelson.
Thank you, Mr. Chairman. I appreciate Representative Moulton's viewpoint on this. I'm actually thinking about the person who is receiving the money, and they also have bills due at certain times of the month. My husband paid child support for many, many years, and he always budgeted and figured out how to pay on time, no matter when he was paid by his company. So I am not in favor of this bill.
Thank you, Representative Gregg.
Thank you. I mean, you can obviously see both sides of this. I worry about us saying like, okay, you're going to pick one of two dates. Every case is different, whether somebody is getting paid weekly, whether somebody's, getting even paid daily or whatever. I think this is best discretion left to the courts. The gentleman, when he spoke on the bill, said, well, if you don't want it the 1st, you can go back to the 15th. Well, you can actually do that right now with 30 to 31 days, sometimes only 28. Go back to the court. I just don't see that us saying, okay, you need to pick one of two dates is going to help anything. And for the same reason, too, we have not only the payer we need to think about, we need to think about the payee. And that is best left to the courts to look at the entire situation to decide.
Thank you, Representative. Representative Grossman.
Thank you, Mr. Chairman. I too think that this could potentially create some conflict in already a conflict area between the payee and the payer in terms of going back to court and filing motions to change the dates that have already potentially been set by the court. So I am not in support of this.
Anybody yet not testified round one? Representative DeSimone.
Thank you, Mr. Chairman. After lengthy discussions with the prime sponsor, although I am a co-sponsor of the bill, it came to our attention that although the thought is a great thought and would help some people, consistency is more important. So I will agree with those who will vote no on OTP.
Moving right along to round two, Representative Moulton.
Thank you, Mr. Chairman. This is more of a question. Maybe I'm misunderstanding the bill, but I didn't think it gave you the ability to just pay it willy-nilly. Like, I just thought that it gave you the ability to just choose a date, but you still would have to stick with it. So there would still be consistency. That's the interpretation that I had.
Representative DeSimone as a sometime co-sponsor.
No, what I meant by consistency was consistency in the court. not consistency in the payments. We would hope that most of the people who are paying child support would be consistent. That's not always the case, but my issue was consistency in the court. And when a couple goes before the judge, they have usually filled out all the paperwork and come to an agreement. And to keep going back and forth to court and saying, well, my employer changed it from I don't get paid on the 15th anymore, I now get paid on the 1st. And I don't get paid on the 1st anymore, I now get paid on the 18th. That's where I'm talking consistency. Thank you for your thoughts, though.
Mr. Chairman, may I? I just,
Yes, you may.
thank you, Mr. Chairman. I totally agree with Representative Moulton. I want to give her a little support here. But I happen to agree exactly with what she said. It looks pretty innocent to me. I know maybe once in a while someone can go back and forth, but let them pick. Let them have some choice.
Representative Long.
Thank you, Mr. Chairman. I agree with Representative DeSimone that if this bill were to pass, you had the option of 1 or 15. So I'm going to go, if I'm looking to drag my ex, bust her chops any way I can, I'm going to say, yeah, I'm going to pick the 1st. And then a month later or 2 months later, I'm going to say, yeah, you know what? I'm going to pick the 15th would be better. So that's given an opportunity to increase the conflict, in my opinion, because you have a choice between the 1st or the 15th. So let a judge tell me that you only get 2 choices. No, it doesn't say it here. No, I have a choice between the 1st and the 15th, and every other month I'd like to change from the 1st to the 15th. And what's prohibited me from stopping that? In statute, it says you could choose from the 1st to the 15th. So I could see an increase in conflict.
Taking a crash course in the law as I am, I would want the phrase to read on either the 1st or the 15th day of the month, consistently month to month. I would agree with Representative Long that as written on either the 1st or the 15th, I could change that and bounce back and forth, and I could weaponize that. So I would agree with you that it's not enough words here. Representative Nelson.
I just actually had a thought when I was, when I was listening to Representative Long. This back and forth could also create the potential of arrearages.
Seeing nothing further, I will call the question. We will be voting on House Bill 126, an act relative to choosing the accrual, which is kind of a pun, date for child support payments, moved by Representative Raymond, seconded by Representative Moulton. The motion before us is ought to pass. If you like the bill, you'll vote yes. If you don't like the bill, you will vote no. Would a clerk call the roll, please?
Chairman Pearson,
No.
Representative Long,
No.
Representative DeSimone,
No.
Representative Bigford,
Yes.
Representative Nelson,
No.
Representative McMahon. No. Representative Ball,
No.
Representative Panic,
No.
Representative Seidel,
No.
Representative Grossman,
No.
Representative Levesque,
No.
Representative Petrino will be voting no. Representative Perez,
No.
Representative Gregg,
No.
Representative Moulton,
No.
Representative Raymond.
No.
Ought to pass fails, 1 yea and 15 nay.
Representative Perez, when I called the question, were you in the room at that time? When I said the clerk may call the roll? then remove one vote. You have to be in the room when the chair says, "Will the clerk call the roll?"
My apology. I'm sorry. I was coming back from the bathroom.
I understand. That's okay. No, it's one of those wonderful times when the vote was one-sided. You may remember my story about how one of our representatives fell asleep. This was on a Zoom meeting, and we did a redo because we wanted him to be recorded. So the motion, the vote, OTP is 1-14. Now, if we could have a positive motion of OTP,
No.
of ITL. If I'm smart at anything, it's surrounding myself by smarter people. Okay, ITL. And I will entertain a motion for ITL. Representative DeSimone.
Representative Seidel, I believe, has had her hand up to make a motion.
She did.
Yes, Mr.
Then you had
Chairman.
your hand up to point to Representative
I-
Seidel.
Can we do
Were you
paper,
stretching?
scissors, rock, or?
Okay, that's either a tremendous halo or you're backlighted by the southern sun. I'm willing to go with it was a tremendous halo. Okay, who has a hand up over here? Representative Governor Gregg. Okay.
So, I'm confused. So Seidel, is Seidel the,
No,
I'm sorry.
Seidel is, it's the
Seidel
side
next to
by
her,
Seidel, side of Seidel, or Greg is moving.
Greg is seconding.
Greg is seconding.
So
Greg
Representative
is
Seidel is
seconding
making
the
the motion.
Who made the motion? Okay, I can't hear you, sorry.
She thought you had made the motion.
Me?
Mr. Chair, I'll make the motion of ITL.
Thank you.
Thank you.
Now we ask for a second.
Now.
Okay.
Okay, the motion before us is ITL on House Bill 126 relative to choosing the accrual date for child support payments. Moved by Representative DeSimone, seconded by Representative Gregg. The motion is ITL. Clerk may call the roll. Everybody here? Good. Okay.
Chairman Pearson,
Yes.
Representative Long,
Yes.
Representative DeSimone,
Yes.
Representative Bickford,
No.
Representative Nelson,
Yes.
Representative McMahon. Yes. Representative Ball,
Yes.
Representative Panic,
Yes.
Representative Seidel,
Yes.
Representative Grossman,
Yes.
Representative Levesque,
Yes.
Representative Petrino will be voting yes. Representative Perez,
Yes.
Representative Gregg,
Yes.
Representative Moulton,
Yes.
Representative Raymond.
Yes.
ITL passes 15-1.
And Representative DeSimone, will you write the report, please?
Oh, okay.
I had bailed you out of the last one. Any objection to it being on consent? Or would you like to defend it vigorously from the floor? No objection to consent. On consent. What's that? I'm encouraged.
They're gonna be,
ITL 15-1. And on consent. Close the hearing on House Bill 126 and now open the hearing on House Bill 124 on temporary alimony with no handouts. Wow, that you don't already have. And Representative DeSimone, this is your bill. You get the honor of making the first motion.
I'll make a motion of, to pass, please.
OTP, Representative DeSimone. Do we have a second? Representative Nelson.
I second.
Discussion, Representative DeSimone. We heard it before. Now make your pitch in exec.
Thank you, Mr. Chair. This bill just, if you look at the bill, it's the bold. It says that the duration limits are under current RSA 458:19-A, and the formula limit under RSA 458:19-A Roman 2. The duration limits under those two RSAs, unless a party seeking temporary alimony pleads and a court finds that immediate and irreparable economic harm would result if the percentage formula were applied. The court then shall make written findings supporting its orders. This is in answer to the multitudes of people who come before us and say that temporary alimony is financially killing them. It just is a difficulty. So if the current formula doesn't work, the court can decide otherwise. And that's why this bill was brought forward. Thank you.
Any other discussion?
A question,
Representative Bickford.
going down those lines, at one time, I think we put a limit of 5 years on temporary alimony, and this wouldn't undo that, would it? You recall in the statute, the 5-year limitation?
May I?
Yes.
It does not mention anywhere in the bill that it would undo anything.
Okay, good. Thank you.
Representative Raymond.
Thank you, Mr. Chairman. So I took the testimony of New Hampshire Legal Aid to heart when they came and spoke on this bill. And I did some research on legal aid, but then also on like alimony and how this stuff is determined and what the, how does the case go through the court. And I know we all talked about this at length that day in regards to some other bills as well, because I just didn't know a lot about how divorces proceeded. And so my concern continues in that the temporary hearing for where you establish temporary custody, et cetera, happens before all of that paperwork is filled out, saying what people's income is, saying like, here's my pay stubs, here's all that stuff. And so I think that it might be challenging to put our judges in a position where they have to apply a formula when they don't have the numbers to plug into the formula. And that's my biggest concern over this language is, I like the idea of a formula. I think the formula is fair and appropriate, and I'm glad we have it in the final orders. I'm sensitive to the concerns people have on how long
leave them at the first class, either over there or over there, you're a representative. Yes, I get that, but they put the test. Yeah, there's not a member. So that's why. I don't mean to be, but you know what? Some people will think that everything. It's safe to say.
To the right. This one. Yes.
Yeah, it goes up. It happens, huh? That's crazy. That's crazy. That's, well, yeah. Yeah, hopefully.
And we don't. But I don't know if there's a law, that's a bill. Yeah, yeah. You know, I asked you to.
Yeah, so, you know, so, yeah, it's harder
We can't, no, we're locked out. Dressing.
Like, who do we turn them into? Thank you.
You need an extra set of copies for the clerk of what was passed out?
I need 2 copies, one for myself
Okay.
personally and one for the file.
Was this passed out to us?
One for the record. Right. Thank you so much.
Okay, as we get going, just want to point out that I believe there is a luncheon today in the cafeteria sponsored by AARP, a wonderful group that never gets old. Opening the hearing now on House Bill 491 relative to prohibiting the use of prone restraints for minors, and the chair recognizes the prime sponsor of the bill, Representative David Muse from Rockingham 37.
Thank you very much, Mr. Chair and members of the committee. What HB 491 would effectively do is 3 things. It would define a dangerous restraint technique known as prone restraint. It would specifically prohibit its use on minor children in New Hampshire schools and treatment facilities. And it would require that adults who use any form of restraint on children be alert for signs of physical distress and to immediately stop restraining the child if they experience difficulty breathing, choking, vomiting, bleeding, or really any physical red flag or warning sign. Prone restraint has become known in another context across the United States in recent years. It's also a technique that is used by law enforcement. And according to a Cornell study, 79 fatalities, according to the Centers for Disease Control, prone restraint, the use of prone restraint by law enforcement has resulted in 107 deaths among adults since 2010. But we're here today to talk about children, and the danger of prone restraint, the danger of an adult often weighing over 200 pounds using this particular technique on a child who may weigh less than 100 pounds is pretty clear and stark. According to Cornell University, between 1993 and 2018, there were 79 fatalities across the country at facilities and schools that actually involved the use of prone restraint. Prone restraint, where we haven't been able to determine if prone restraint has ever resulted in a fatality in New Hampshire, but we do know that it's resulted in at least one lawsuit. In 2018, one of the residents at the Sununu Center was slammed to the ground and held in prone restraint in such a manner that resulted in the child breaking his shoulder. So this is something that that has happened, and I think it shows that not only is there a danger of death when a technique like this is used or employed, there's also the danger of a serious injury. Other people are going to testify today as to specifically how prone restraint causes harm and how it causes trauma in a child. So I won't get into that in my testimony, but I did want to let you know that the bill and the amendment that you've received this morning have been reviewed by the New Hampshire Medical Society, the Psychiatric Society, the Pediatric Society, the Disability Rights Center, DCYF, and several other organizations that will either be here today or offer online testimony. This is, in many respects, this bill in some ways is a housekeeping bill because our current statute, RSA 126U, actually does prohibit prone restraint now. The problem with the statute as it now stands is it doesn't specifically call out or name prone restraint by name as a prohibited technique. It doesn't define prone restraint. And the current statute also doesn't set any guardrails on the use of restraint. So, for example, a person applying restraint, there are no guardrails that basically tell that person when to stop. You know, when should you actually stop? When does the physical distress of a child reach the point where it's important to stop this before harm is done? So essentially, this bill and the amendment address these issues. The amendment itself is a full bill amendment, and what it does is it changes the statement of findings to actually reflect the fact that the current statute, the way that it's worded, actually can be read and interpreted to prohibit prone restraint. But one of the things we're trying to do with this bill is to close the ambiguity to make sure that the current policy is enforced more consistently and effectively. So that's really the goal here. The goal isn't to ban prone restraint because we think that the current RSA already bans prone restraint. But what we're really trying to do is just make it crystal clear to everybody involved that this is a prohibited technique in the state of New Hampshire. We don't want facilities to use it, and that when we apply any form of restraint, we need to put the health of the child first. So that's essentially what we're trying to do, and I'd be happy to answer any questions that the committee has.
The chair has one. I have 3 family members who are in law enforcement and several who are in medicine. And the concern is for their safety as well. So I looked at this bill with that prejudice in mind, that I wish to keep those people safe, especially from someone high on drugs and an older child who has great physical strength. And what I found pleased me in both your bill and the amendment, because it is talking about keeping someone in that position indefinitely, which circling back on my family, said, oh, we agree with this. We don't want to keep it's if it is used very transitorily along the way to something else that is less dangerous. So, having heard from all the medical people and all the police people in my family who they signed off on this, thank you, sir, for this bill.
I'm glad to hear that.
Would you believe? I had to make a question.
I would believe.
Any other? Yes, Representative Bickford.
Thank you, Mr. Chairman. I was noticing the same thing, and it's in your italicized addition here, and you use the word in the first sentence, prohibited physical restraint. And then you come down here and talk in the next sentence about, for the purpose of definition, physical restraint that involves a temporary controlling of an individual in a prone position. Now you've accepted and said, yeah, if we can do it temporarily. However, you need to stop doing it as soon as possible, basically what you're saying here. So you've said it's okay to do it temporarily, then you say it's prohibited in the first sentence. So I'm thinking, well, maybe saying it's prohibited in that is not the right word to use, that should come out of it.
One of the things that I heard when I was doing research for the bill is that there are situations where essentially sometimes it's necessary for a staff member to almost tackle a person in order to prevent them from harming themselves or harming another person. So in that context, that's why the exception is there. The idea is there may be times when a staff member may find themselves, effectively using this, that the child may be on, maybe on his stomach. But I think one of the things we wanted to do is to provide clear direction that is supposed to end as quickly as possible, and you are to move to another form of restraint. And my understanding is that DCYF actually issued a memo in 2019 that actually discusses prone restraint in New Hampshire. And as a result of sending that memo out, and we have a person from DCYF here today, as a result of sending that memo out, several schools and treatment facilities have stopped using prone restraint. And in the place of prone restraint are using other safer techniques. So I think that's one of the things that we do have to navigate is that occasionally there's a need for the use of this technique to protect the child, to protect other people at the facility. But the child's health and safety really always has to come first, and I hope that this language makes it clear that we're putting those children first.
Representative Moulton.
Thank you, Mr. Chairman. I'm just wondering if this also covers in homes. Like, should there be domestic violence going on, or, for some reason, a restraint was used at home? Does this also cover that?
It does not. Part of any of these restraint techniques, my understanding is that facilities do train and have training programs for their staff members in the use of restraint. The average parent probably wouldn't have that kind of training.
Right, the average
Would you like
parent,
a
but-
follow-up?
Yes, I would like a
I
follow-up.
thought so. Go
Thank
ahead.
you.
You're welcome.
My concern is if we added language in to say that prone restraint was illegal in homes, then that could add a charge for someone who was being domestically violent. So in other words, there's not a need to prone restraint a kid, but because of an abusive individual that's in the house, they're using it as an act of power and control. And by formulating that it's illegal, then they could be charged for such.
And the bill is now in the hands of the committee to do whatever the committee would like to do with it. What I would say is there are advantages to having a more focused and narrower bill in this particular case, in that this is a needed change, and I think we have a good amendment, a good bill in front of us that I hope a majority of members on the committee can pass. My concern with what you raise is that it might add another layer of complexity that might raise opposition. So it's sort of, I don't think we ever want to get in a situation where we want to sacrifice the good in favor of the perfect. So that would be my comment.
Representative Raymond.
Thank you, Mr. Chairman. Thank you, Representative Muse, for coming to speak with us today and for taking my question. I have a question regarding RSA. Oh, shoot, I just lost it. RSA 126U, and then there's a number of letters after Roman numerals after that, which has a lot of definitions about restraint already in it. That RSA and part of, I forget, SB 324 or something back in 2014 required a certain level of training for individuals whose jobs require them to use restraint on children within the state. Do we know if the training that is being provided through CPI or other training providers covers not using prone restraint? And is there a way that we can find that out, or do we need a bill that specifically says that training would have to cover this particular type of restraint?
We actually have some folks who are going to testify later who are from facilities who do not use prone restraint. What I would say is that does vary from facility to facility, and part of the reason we're here is that RSA 126U doesn't specifically prohibit prone restraint by name or define it.
Right.
So there's a little bit of ambiguity. And when you think about the complexity of training a person, if you're talking about training a person not to do prone restraint, you can actually show them a picture of what it looks like and put a big X through it and say, don't do that in big letters, right? Whereas the way that the current statute is written, you're sort of scratching your head going, is this banned? What's banned? What is it really banning? It's anytime. It's a little complicated for training purposes, and the potential is there for it to be misunderstood or misinterpreted, and we're just really trying to close that loop. We're not changing the language, so to speak, of that, but that there's some good wording in there when it comes to all forms of restraint. But we just want to make sure we're a lot clearer going forward.
Thank you.
Thank you, Representative, for bringing us this bill. What? Oh, hi. Representative Grossman has a question.
Thank you, Mr. Chairman.
Entschuldigen Sie.
Yeah.
Bitte. Ja.
Thank you, Representative Muse, for bringing this forward. This is really important work. Initially, I was going to ask about training, so what alternatives are being offered, and it seems like we'll get some answers potentially to that later. What would the consequence be if this were passed and someone did use restraint in terms of a child? And I apologize if it's in here and I didn't read that yet, but so if we are going to make it illegal, you can't use it, what happens if somebody in a facility does use it?
The bill doesn't change penalties, and to be honest with you, I've been so focused on that one part of the bill that I haven't been particularly focused on changing penalties or things like that. I do think there is someone here from DCYF who would be much more familiar with actually how this is enforced. And one of the things that we're also hoping to do with this bill is by clarifying the policy, we're hoping to make it easier for DCYF to enforce this consistently across the state. I don't think the idea is to have people lose their jobs or criminally charge people or anything like that. We just want people to understand the policy, understand why we have the policy in place, so that essentially we're not unnecessarily putting kids who are already really vulnerable for one reason or another at even more risk. So that's really what we're trying to do.
Anyone else from the committee for the representative? Seeing none, thank you so much for presenting your bill. And now we are going into the 3-minute drill, which means 180 seconds. And at 3 minutes, I have a cutoff switch and your microphone goes dead. And I've already shared with the committee the best speech I heard last year speaking to a bill was 37 seconds long. I owe that person 2 minutes plus whenever she comes here. So with this 3-minute bill limit, please, Chair recognizes Holly Stevens from NAMI. And she's got some handouts for all of us.
Good morning, Chairman Pearson, members of the committee. My name is Holly Stevens. I'm the Director of Public Policy for NAMI New Hampshire. NAMI New Hampshire is a nonprofit grassroots organization whose mission is to improve the lives of all people who are impacted by mental illness and suicide through support, education, and advocacy. On behalf of NAMI New Hampshire, I'm here today to support House Bill 491 relative to prohibiting the use of prone restraints for minors. In our reading of the bill, it appears, as you heard earlier, that this is just a clarification of the law and not a change of the law. The exact citation is New Hampshire RSA 126-U:4I, A through C, comma D. For us to know that prone restraints are continuing to be used in the state of New Hampshire is extremely concerning, and the fact that this bill needs to be brought forward is extremely concerning. I reviewed a research study. There was a 26-year study of the use of restraints on children in facilities from 1993 to 2018. They found that there were 63 deaths that were related to physical restraints, and of those 63 deaths, 38 were related to prone restraints, but of note, 19 of them, the restraint type was undetermined. So again, 38 of the 63 were prone and 19 were unknown. We also know, in a particular concern to NAMI, that physical restraints are used regularly with children and adolescents in mental health care. The study found that the deaths occurred with children and adolescents who were in psychiatric facilities, residential treatment facilities, group homes, foster homes, and juvenile correctional facilities. That was the majority of the deaths. The evidence is clear that prone restraints are dangerous and disproportionately affect youth and mental health, youth with mental health issues, and should not be used on any children and adolescents. Therefore, NAMI New Hampshire urges the committee to vote this bill ought to pass. Thank you, and I'll answer any questions you may have.
Any questions? Thank you, Ms. Stevens.
Thank you.
I owe you 32 seconds. Next time.
I'll write
Chair
that
recognizes Michael Skibby from Contoocook. I only say that because it's taken me years to learn how to say it.
Good morning, Mr. Chairman, members of the committee. My name is Michael Skibby. Here to support the bill and the amendment that is being proposed by Representative Muse. I was policy director at the Disability Rights Center when the child restraint law was originally passed in 2010, and then when it was substantially amended in 2014. My objective is to give you an understanding of the reasons for this legislation, the legislation that led to the current statute, and the reason that we really need to adopt this bill to clarify the current state of the law. Before 2010, our office at the Disability Rights Center was involved in a number of cases and investigations of restraint causing significant and serious injury to children in both public schools and treatment facilities. At the same time, there had been a growing national understanding of the inherent dangers of certain kinds of restraint, including prone restraint. The United States Department of Education had issued some guidance. Medical research had become more sort of well understood. And so Senator Scombati, who was the former deputy director of the Department of Health and Human Services, and had a deep understanding of restraint and its dangers, sponsored the bill that led to current Chapter 126U. While the bill was being considered, one or two facilities that provided treatment to children strongly objected to the use of the term prone restraint in the list of prohibited techniques. And they maintained, stridently and vociferously that, notwithstanding everything that had become known about the inherent dangers of this technique, that they could do it safely. But at the same time, and during the hearings that were ongoing regarding the legislation, the chief medical examiner of the state, Dr. Thomas Andrew, who is here today, testified in detail about what exactly happens to someone when they're subjected to this technique and how dangerous it really is. It adheres, among other things, it interferes with the movement that's required for normal breathing. Senator Scombati was very concerned about the objections that were being raised, but was also very committed to the prohibition on prone. And so she asked us to develop language that would address dangerous restraint techniques and positions without using that term that was triggering so much objection. And so my colleague, now Senator Whitley, and Dr. Andrew and I consulted about how to accomplish that, and we came up with the language that is in the current statute that I distributed to you just now. And I've
You have
highlighted
15 seconds to close, please.
I've highlighted the sections that I think address it. And I think if you imagine yourself being face down on a hard surface like a floor or a table, that it would definitely do the things that this prohibits. It would cause compression of the chest. It would impair the movement that's required for normal breathing. So we do believe that it does prohibit it, but that unfortunately some facilities are still using it. We ask you to adopt this or to recommend passage of this bill so that we can further protect the children.
Thank you. Any questions for Mr. Skibby? Yes, Representative Bickford. Microphone.
My concern, Mike, is the word temporary is in here. We're prohibited from doing something. Then we said we can do it temporarily. How long is temporarily?
I think that, if I can grab it here. I think that the key phrase for me in understanding that sentence is that it's the temporary controlling while transitioning to an alternative, safer form of restraint. And the way I think about this is that when you initially engage physically with a child that is upset, maybe, in a fight with someone or something like that, that it takes a little bit, maybe just seconds, to gain control of the situation. And you may find yourself with hands on a child with their face down, and that could be considered a technical violation of this language. So I think that adding this language makes it clear that as you're gaining control, you may have a kid face down, but you would not thereby be violating the statute. That's how I understand
So
it.
transitioning is the key
Exactly.
word.
Yeah, I think so.
Okay, thank you.
Any further questions for Mr. Skibby? Seeing none, thank you so much.
Thank you.
Are you enjoying your retirement?
I am. Thank you very much.
Well, I miss you from the committees here, so thank you for coming back.
Good to see everybody.
Yep. Chair recognizes Karen Rosenberg from the Disability Rights Center of New Hampshire.
Good morning, members of the committee. I'm Karen Rosenberg, the Policy Director at the Disability Rights Center. I'm testifying in support of HB 491 on behalf of the Disability Rights Center, as well as the Juvenile Reform Policy Group, which is a coalition of organizations that advocate for the health and well-being of our children. That includes New Hampshire Legal Assistance, Waypoint, New Futures, the Children's Law Center of New Hampshire, and the ACLU of New Hampshire. So first, I think it's really important for everyone to realize there is no evidence-based research that supports using restraint as a therapeutic intervention. We're talking about situations that are emergencies when no other less restrictive, less onerous technique can be used to control a child who's in a school or a facility. And so Representative, I think it was Moulton, asked the question about how it would potentially impact families. This is not a bill that impacts families. This law only regulates the use of restraint or seclusion in schools and treatment facilities and foster treatment facilities. Okay, as you've heard, our law currently prohibits use of dangerous restraint techniques, which includes prone. And for the most part, facilities and schools are successfully managing even dangerous children's behavior without using this technique. Even facilities that are under contract with our Department of Health and Human Services that are like level 4, really, very challenging children, have figured out how to address really dangerous situations using safer techniques when they need to put their hands on a child. But it's come to our attention that there are some outliers that didn't really get the memo and don't really interpret the law the way it was intended. And so since the passage of the law, we have become aware of situations where children have suffered serious injuries due to the use of prone restraint, including one where a child suffered a fractured scapula, your shoulder blade, and another in which a student lost consciousness for a period of time during the course of a prone restraint. So we want to make sure that it is abundantly clear that we mean it. We should not be using dangerous restraints on vulnerable children. That's really what this is about. So, and also that if a child is in any kind of restraint, that the person involved in that restraint needs to pay attention to their health and well-being. And so that's why there's also in this amendment, and I think in the original bill, there's a requirement that the child's physical condition be paid attention to so that they can be released if there's any sign of distress. So if I have time to answer a couple of questions that were raised, I think Representative Raymond maybe asked about complaints and like what would happen to someone. Is that you? No, you asked about training. So there is a requirement that the Department of Education and New Hampshire Department of Labor, it's in the current law, assists with training materials, and any reputable training organization is going to train facility operators and schools to avoid the use of restraint whenever possible, to apply research-based alternatives that will help the child to learn to regulate and de-escalate, and will be in conformity with our state law. And I think it was Representative Grossman that asked about, well, what's going to happen to these people? We already have processes that's required by state law and now in state rule for complaints to be filed. That's in, I think, RSA 126U9. And that so under those, it's U9 and U8, depending whether it's a school or a facility that's overseen by the Department of Health and Human Services. So there's a requirement that there be an investigation process and a process for addressing what injuries the child may have suffered as a result. So I hope that answered your questions. I hope I kept it under 3 minutes.
Actually, your speech was under 3 minutes, and then you answered questions. Any further questions? Representative Panic.
What is the definition of a child, age-wise?
Well, it depends if they're still in school or not. So for, I actually need to look at it. So for children who are, generally it's under 18 years of age. However, if a child is either in the juvenile justice system and has voluntarily extended their jurisdiction, the court's jurisdiction, because they have not obtained a regular high school diploma, or they're in school through the public school system because they've not earned a diploma, then and they're less than 22 years of age, those individuals would also be covered by the definition of child. It's meant to regulate what happens in schools and facilities.
One follow-up.
So if a child came into school who's 20 years old, the school's definition of a child, with a gun, and the child needs to be restrained, that wouldn't restrict that type of...
No, this does not prohibit schools from using restraint. Okay, restraint can be used.
Okay.
And what this says, though, is that we should not be using dangerous restraints on people. And prone restraint, which is actually prohibited under our law, given how our law defines dangerous restraint, should not be the go-to restraint. So if someone needs to be restrained, and that's a very dangerous situation, if that's the intervention, there's nothing in our current law, or if the law is amended, that would prevent that from happening.
With the goal as quickly as possible to move to less dangerous.
If the restraint ended up in a takedown to the floor and the person ended up face down, then yes, the goal would be to put them in a safer position and contain them. Take away the gun.
Any further questions for Ms. Rosenberg? Representative Raymond.
Thank you, Mr. Chairman, and thank you, Ms. Rosenberg. I think it might be helpful for the committee, and it would be helpful for me. Are you able to give us some examples, or perhaps another speaker, I'm not sure, of situations where restraint is used currently in school settings or group treatment settings, like a situation where people are trained to use restraint that is appropriate to use a restraint. So for example, like when I hear this, I don't think of someone coming in with a gun. That to me is a law enforcement response. I think of this as a child with a meltdown. Am I on the wrong track?
Yeah, I'm not aware of, and I hope I'm never aware of a situation with a gun. But so it's a situation in which a child's behavior is such that they pose a substantial imminent risk of causing serious bodily harm to either themselves or someone else. That's what how the law defines it. So as an illustration, there's some altercation between two students, and one student is really wailing on another student, right? So they're going to hurt them. A staff member could separate the children and in doing so, hold on, and maybe with another staff member too, to the child, and to eliminate that, to try to control that risk and hold on to the child, assuming they're still flailing and dangerous. Does that help you?
Yes, it does. I'm trying to envision the circumstances in which this happens. So, a fight at school, or I'm thinking an elementary school child who's, having an issue of throwing things or something like that.
Well, it could also come
no.
up, like we've seen situations with kids like with autism who have sort of a flight or fight response. And so over the years that I've been at DRC, we've had situations where a child bolts. So they're like in the playground and something interests them or something's going on and they're bolting towards the street. And so that would be dangerous. And a staff member and teacher could then, grab the kid in a safe position and prevent them from bolting into the street. That might be another example that comes up pretty regularly.
Representative Moulton.
Thank you, Mr. Chairman.
Mr. Chair, point of order, please.
Yes.
Representative Moulton
Oh,
is
excuse me.
a
That's right. You're-
co-sponsor.
Thank you.
Thank you.
I forgot to announce that Representative Moulton and Representative Levesque are co-sponsors of the bill, so may ask questions of the prime sponsor only, but no one else. Thank you for that. I meant to do
Sorry.
that. I forgot
Your
that.
questions are great, but protocol. Thank you.
I'll tell you later about how you can work around that. Representative Knurk and I almost got thrown out for doing it, but I'll tell you. Yes, anyone else for? Oh, I'll tell everybody. Jerry wanted to ask a question and he couldn't, so he slipped me a piece of paper. And I'm reading it as if it were my question. But Jerry is a doctor. So halfway through the question, I said, "What's that word?" At which point I totally outed both of us.
That's a great story. And I've learned something today. I didn't realize that was prohibited. So thank you.
So, this is Fox guarding henhouse chairmanship here. All right, any other questions for Ms. Rosenberg from somebody who can ask them? Thank you.
Thank you, everyone.
Chair recognizes Dr. Thomas Andrew.
Thank you, Chairman Pearson, and thank you to the committee for hosting me this morning. My name is Tom Andrew. I'm a forensic pathologist and served the Granite State as your chief medical examiner from 1997 to 2017. Now, since retirement from state service, I've remained active as a forensic pathologist, as a consultant, and in teaching. Now, I did not testify before legislative committees very often in my 20 years as chief medical examiner. I reserve those times for when I felt strongly about the issue at hand and when I thought I really had some legitimate expertise to offer. Over a decade ago, I testified on the dangers of prone restraint, and I'm back today to support HB 491's aim to prohibit prone restraint specifically by name. That prone restraint is still used due to language vagaries in the current law is an anathema to one who has seen firsthand fatal results from the use of this technique. As far back as 1996, forensic pathologists alerted by Don Ray, chief medical examiner in Seattle, began to recognize the inhibition of effective ventilation during prone restraint as it involves two key factors in the physiology of respiration or breathing: movement of the ribs and movement of the diaphragm. Now, prone restraint restricts rib movement, particularly and especially, but not exclusively, if weight is applied to the person's back. Now, obesity of the victim of a fatal episode of prone restraint, not uncommon, I might add, is an exacerbating factor because it pushes the abdominal contents upward, restricting the movement of the diaphragm. Now, these anatomic factors reduce respiratory volume, the amount of air that you exchange. Limitation of respiratory volume may be of no significance to a healthy person at rest. This is the apparent basis of the misguided notion that this technique can be practiced safely. But the circumstances of fatal cases, seen hundreds of times by forensic pathologists around the country, and several times by me personally, are very different. The victim has nearly always been involved in a high, intense physical activity that prompted the restraint in the first place and then actively resisted the restraint. Even after being subdued, they continue to struggle, incurring further oxygen debt. Now, additionally, this victim is subjected to high levels of circulating adrenaline due to their emotional arousal, mental illness, or, as can be seen in encounters with law enforcement, the use of illicit stimulant drugs. Now, adrenaline in excess has an irritant effect on the heart, and the heart's ability to conduct normal electrical impulses is impaired. And this is an unpredictable factor that can bring about very sudden, unexpected, lethal arrhythmias or electrical short-circuiting of the heart.
Please wrap it up, doctor. About 15 seconds.
That can kill in seconds. Now, experience has taught us that the level of restricted ventilation that might be harmless to a healthy person at rest may be in such circumstances fatal. Now, this is not a novel theory. A comprehensive review of restraint deaths in 2021 in Medicine, Science, and the Law highlighted this underappreciated aspect of prone restraint.
Will you take questions, doctor? Well, we just got a ruling from on high, and it says that unless you are testifying, you may ask questions. So the Knerk-Pearson protocol has been replaced. Any questions for the doctor? Representative Long.
Thank you, Doctor. Thank you, Doctor, for your testimony. The questions, sir? Well, I could have your people call my people and we could get it all taken. Doctor, with respect to, I mean, looking at this, I've always thought of restraints if they're on their back. Is some of that consistent with what you said when they're on their face? I mean, I would think a larger person on their back would have that breath. Have you seen instances of people on their back restrained that are detrimental to their breathing or their health?
On their back?
Yeah.
That supine restraint?
Yeah. Okay. I didn't know that's what it was called.
Well, that's, if you're on your back, you're supine.
Okay.
If you're face down, you're prone. Prone is inherently dangerous. So, restraint of any kind incurs risk. Prone restraint, when you're face down, is inherently dangerous. If I had a choice, I would prefer to be restrained supine, face up.
Okay, great. Thank you.
Representative Gregg.
So it's of your opinion that no matter how good the training or is anything, that this prone is a problem?
It's not my opinion. I think that it is the a consensus of evidence-based medicine. I'm merely representing what the literature supports.
Thank you so much.
Representative Panic.
Thank you, Chairman. Thank you for taking my question.
A little closer to the mic, please.
Sorry. Thank you. Is the amount of pressure given to the person being restrained in prone position a determining factor on the severity of the injury or death?
It is not a determining factor, and that's why I said especially and particularly, but not exclusively. In the prone position, even without extra weight being added onto the back, which is a rarity in these situations, there's almost always somebody across the shoulders or the back or the abdomen. But even without that, rib motion, rib movement against an unyielding surface like the floor, even a carpeted floor, is still a significant factor. And what is not accounted for here is the potential cardiac toxicity of excess adrenaline. That's why the restrained individual, even if, in quotation marks, is being monitored, they can have a sudden lethal arrhythmia leading to heart stoppage, even if they are clearly breathing right up to the moment that that their heart stops. This is not predictable. They're not blue. And if they have a lethal cardiac arrhythmia, well, the game's over before anybody can do about it. And often before they even realize it, because they're looking for cyanosis or blueness in the face or stoppage of breathing. This is dangerous activity.
Representative Moulton, with her newfound freedom. may ask
Thank
a
you,
question.
Mr. Chairman. For one, thank you, Representative DeSimone, for reminding me that I was a co-sponsor of this bill, because that was back in December, and I knew I had co-sponsored some bills, but this one in particular. But regardless, I'm a registered nurse. We do restrain patients, and I wanted to make a comment that I have to word as a question. So if you would believe that in hospitals in adult care only restrain patients that are confused and violent or just violent, that's the only time where we restrain adult patients. So they have to be a threat to themselves or others. And in the adult setting, we don't use prone restraints like ever. And then the other caveat to that is that we need to release them as soon as they are calm, because we don't restrain people that don't need to be restrained. So that's been the policy everywhere that I've worked. So I was just saying, I was aiming it was more of a comment than a question, but.
You're wondering if the good doctor believes this.
Would you believe that what I testified?
Having autopsied an individual who died in prone restraint in a healthcare facility here in New Hampshire and seeing that policy in that facility change, yes, I believe it. And my sainted wife, who is a psychiatrist and was employed at a New Hampshire hospital for 11 years, saw any number of necessary takedowns of people acting dangerously. But after they were taken down, as soon as was feasible, they were removed from the prone position to a supine position or other position wherein a restraint can be more safely applied.
Thank you, Doctor. I'm glad you stayed for questions. If you had written testimony that you were reading, would you mind sharing it with the clerk for the record? Thank you. Chair now recognizes State Representative Maria Perez.
Thank you. My name is Maria Perez. I'm a state representative from District 43, and I'm here to speak on support HB 491. I will say thank you for the sponsors and the co-sponsors of this bill. As someone who worked with special needs students back in the days, this is very critical. I believe when someone is having a broken moment in a crisis, the least thing that they need is feel like unsafe and feel hurt. Especially when we're dealing with kids with autism, language barrier, and sometimes religion. You know, we need to remember that, you know, we all different, and I'm so thankful that this bill was introduced, and I will ask everyone in the committee to support this bill.
Thank you for your testimony. The chair recognizes Crystal Bishop. And I want to see if she can do it in 3 minutes. And your time starts as soon as you turn the mic on.
Thank you. Hi, thank you. My name is Crystal Bishop, and I'm a nursing student at the Mass College of Pharmacy and Health Science. I am reaching out to you with regards to the House Bill 491 relating to prone restraint of minors. I support the passing of this bill as it states prone restraint should be specified in current restraint and seclusion laws, ultimately forbidding its use. Prone restraint is one where a minor is forced face down on the floor and has pressure applied to their body in order to keep them in the prone position. The use of prone restraint increases mortality among children due to the risk of altered respiratory and cardiac function when forced pressure is applied. Restraining minors should be a last resort. De-escalation and crisis management strategies should take precedence over the act of physically, chemically, or environmentally restraining a minor. Not only does it not benefit their physical health, but it also compromises their mental health by increasing trauma-related care. If restraints are necessary for the safety of the minor or someone around them, a seated restraint should be utilized. As a mother to a 7-year-old boy, I have concerns that the use of prone restraint is still an option due to the ambiguous wording of current law. With increasing concern over safety issues in schools over the past several years, prone restraint should not be included in those concerns, as it is within our means to outlaw its use. It is my hope that you will approve this bill to forbid the use of prone restraints for minors. Thank you.
Wow. It can be done. It was done wonderfully. Thank you. Where's your school located?
We have 3 campuses, but I'm on the Manchester, New Hampshire campus.
Okay, good. Thank you. Any questions? Okay, the alderman from Manchester says it's the best of the 3. Keep the money coming. Any questions for the nursing student? How long do you have to go?
We're 3 months. April. I'm graduated. Yes.
Congratulations.
Thank
Thank
you.
you for your service. We need you.
Thank you.
Chair recognizes Beth Morgeson from DCYFGC/LL. Do I have all that right? General Counsel. Okay.
Yes, I'm Beth Margison. I'm the General Counsel and Legislative Liaison for DCYF. I just am here to provide information to the committee. Since 2019, DCYF has sent out a notice to our treatment programs discouraging the use of prone restraints, except for in times where you need to get control of the person and move them to a safer restraint, and also for purposes of safely transporting them. I'm sorry, I can't really see the people over there. So we just wanted to provide that information to the committee. And, obviously the division does not run schools or treatment programs. So this is an annual notification that we make to our treatment programs. So if there's any other questions, I'll be happy to answer them.
Thank you, Counselor. Seeing none, thank you so much.
Thank you.
The chair recognizes Jennifer Jones from the Office of the Child Advocate. She has handouts, and she has boiled her testimony down to 3 Minutes. Oh, excuse me. No, that was a mistake on my part. No, it's just I'm having a brain cramp here. Thank you.
Good morning, Mr. Chairman and members of the committee. I hope to dazzle you with a under 3-minute testimony, as the folks behind me have done such a beautiful job of narrating the support that the Office of the Child Advocate also has in support of this bill before you today. So I am one of 2 assistant child advocates, and I'm here on behalf of the child advocate for the state of New Hampshire, Cassandra Sanchez, who had unavoidable conflict with being here today. So while we largely support, again, the testimony that you've already heard, one thing that I think is really important to impart from our office's perspective, as we really, we really are aim to be a voice of the children in the state of New Hampshire, is how children actually feel, how children and youth actually feel about prone restraint. And so I want to provide an anecdote from a youth that our office recently had communication with. And this was a youth in a more restrictive placement setting and was prepared to be stepped down. And when interviewing with different placement providers, this youth expressed significant concern about whether or not the providers that they would be interviewing with would use prone restraint. And so, the child noted that they understood how dangerous this restraint is and had seen news articles where children had died as a result of positional asphyxiation when in prone position. So again, I hope to impart on you the voice of children in our community and what youth are thinking about and being faced with. What we know about children in residential placement is almost all largely have trauma backgrounds. So the idea that there's a restraint being used that can provide can create additional trauma is simply unacceptable. And I think our children are saying that as well.
Thank you so much. You did great. You originally wanted 15 minutes and you boiled it down. So you are in my Hall of Fame.
Wonderful. It's
Any
a great
questions?
place to be. Any
Mr. Chairman?
questions?
Any questions?
Mr. Chairman.
Yes, Representative Bickford.
Thank you, Mr. Chairman. Your letter you passed out,
Yes.
it seems to cut off. Is there more that we should know? It says, although the Office of Child Advocate firmly believes prone restraint.
So you want to take the first 2 pages before you hand it out,
Huh?
pass it down. There's 2 pages.
Oh. Okay, thank you.
It's
Okay,
a common
hold that.
mistake. Any other questions for either page? Seeing none, thank you so much.
Thank you so much for having me.
And now from Waypoint, Keith Koenig. I'm going to pronounce that UE as if it's U umlaut. For our German friends here. Yes. Would you hold for 1 minute? Some laughs can't be stifled, and we want this one to have its full run. You good now?
It has page 1, but no page 2, and I have page 2, but no 1.
Well, have lunch together and discuss it.
Good morning, Mr. Chairman, members of the committee. For the record, my name is Keith Kinning. I'm the advocacy director at Waypoint, and we support HB 491 with Representative Muse's amendment. Representative Muse spoke some time with my CEO, Borja Alvarez de Toledo. Borja could not be here today, but he felt like it was so important that he asked me to publicly testify on behalf of Waypoint. And this is a brief statement we have. House Bill 491 clarifies the intent of RSA Chapter 126U to ban prone restraint and ensure the safety of children, clarifying the prohibition of prone restraint is critical not only from a safety perspective, but also from a clinical perspective. Most kids in residential facilities who find themselves subject to prone restraint have trauma histories. As a result of trauma, children may respond to triggers with uncontrollable fear and or aggression. Restraints exacerbate this trauma and impede progress and recovery, even in the absence of physical injury. Prohibiting prone restraint requires those caring for our most vulnerable children to better understand the child's needs and triggers, thereby avoiding the use of restraint and providing effective care and treatment. So that is Waypoint's statement. Thank you very much for your time.
Any questions? Thank you. The chair wishes to read into the record a statement from Michael Padmore from the New Hampshire Medical Society. Mr. Chairman, I just wanted to send a note ahead of 491 hearing this morning. I will not be able to testify, but I did vet the bill with our psychiatric and pediatric community. Both are in full support. This text was under 3 minutes. Thank you, Mr. Padmore. In consultation with the vice chair and ranking member, I think we're on a head of steam, and I'd love to pass this, I'd love to exec this bill while all of you are here. So I asked the vice chairman if he would do a side-by-side to give us a very quick overview as to how the amendment changes the bill. And I do appreciate it. It's a full text amendment. Those are actually easier. So, Mr. Vice Chairman.
Thank you, Mr. Chairman. Would it be in order to
yes, it would.
Introduce Amendment 2023-0112H on House Bill 491?
You let me move the bill. I move House Bill 491 with Amendment 112H as ought to pass. Is there a second? Second by, yes, the dynamic duo of page 1 and page 2, friends. Now, you may go ahead.
Okay, thank you, Mr. Chairman. I spoke with the sponsor and statement of findings 1, 2, and 3 in the original bill doesn't articulate well enough that prone restraint is prohibited. So in the amendment that we're talking about, 1, 2, and 3 clarifies that. And that's one of the changes. The other change is on line 27 on the original bill, appearance of pain was removed for the reason being that a child who knows the system can certainly give an appearance of pain. And that's
mine did.
That's the amendment. That's what changes in the amendment from the original bill.
In your opinion, is it really just a little bit of clarification?
It is.
Yep.
And just one other thing, I if I may, Mr. Chairman, the sponsor told me that DCYF may have wanted a change. Is that?
No, actually, there was concerns because we often, for transporting a child, we will need to restrain them behind their back. However, that is done in a standing up position, not in a prone restraint position.
Okay, great.
I just want to, because
Thank you. So
Rebecca
so-
Ross knows much more about these things than I do. I just want to make sure, because we do need the ability to restrain a child standing up. So, but it seems fine.
Now, with that, I will close the hearing on House Bill 491 and do what I should have done a minute ago and open an exec session on House Bill 491, and the chair moves ought to pass with Amendment 0112H, and Representative Perez is seconding it. Now we can do what we were doing.
Yeah. So
we can further discuss. I would use the phrase slam dunk, but that could be misinterpreted. Representative Raymond.
I'd just like to say I don't think more discussion is warranted. That we had a number of very articulate and experts who testified in favor of this bill. They explained to us very clearly what the medical repercussions are of using this type of restraint. And I think if we keep in mind that our jobs here are to act in the best interest of children, that we will vote this ought to pass.
Any further discussion? Representative Long.
Thank you, Mr. Chairman. I just a clarification from the clerk. Was it, I believe I made a motion on accepting the amendment. And did you get a second?
I'll second.
All right, Representative Long moves the amendment and Representative DeSimone seconds the amendment. Trying to write and think at the same time and talk. Seeing no further discussion, if the clerk would call the roll on the amendment 112 to House Bill 491, moved by Representative Long, seconded by Representative DeSimone. The motion is
To accept the amendment.
ought to pass.
Ought to pass.
Ought to
correct.
pass, okay.
On the amendment.
On the amendment,
On the amendment.
on the amendment.
Chairman Pearson.
Yes.
Representative Long.
Yes.
Representative DeSimone.
Yes.
Representative Bickford.
Yes.
Representative Nelson.
Yes.
Representative McMahon.
Yes.
Representative Ball.
Yes.
Representative Panic.
Yes.
Representative Seidel.
Yes.
Representative Grossman.
Yes.
Representative Levesque.
Yes.
Representative Petrino will be voting yes. Representative Perez.
Yes.
Representative Gregg.
Yes.
Representative Moulton.
Yes.
Representative Raymond.
Yes.
The amendment passes 16-0.
And now the motion on the floor is House Bill 491A, moved by Representative Pearson and seconded by Representative Perez. Call the question. The clerk may call the roll.
Chairman Pearson.
Yes.
Representative Long.
Yes.
Representative DeSimone.
Yes.
Representative Bickford.
Yes.
Representative Nelson.
Yes.
Representative McMahon. Representative Ball.
Yes.
Representative Panic.
Yes.
Representative Seidel.
Yes.
Representative Grossman.
Yes.
Representative Levesque.
Yes.
Representative Petrino will be voting yes. Representative Perez.
Yes.
Representative Gregg.
Yes.
Representative Moulton.
Yes.
Representative Raymond.
Yes.
Ought to pass with amendment. Passes 16-0.
Any objection to consent? The chair will be honored
Question
to.
on consent?
Yeah.
I don't know if this should be on a House floor because it'll bring awareness that this, I mean, a consent, it'll just be a quiet pass through. So I don't know if we just want to get a vote on the floor. The consent's okay? Okay.
I don't want to risk it.
Okay.
Plus, I'm going to write a brilliant blurb.
Oh. I'll get it in union later.
Well, I hope so. I mean, it's actually.
Just put all of our names on it.
Mr. Landrigan in the house anywhere? This one's for you, Kevin. All right. This closes it. I wanted to do this while you were here and all of you were here.
Thank you all.
Thank
for
you.
being here. This was very helpful.
Thank you, Representative, for
Just remember, AARP is feeding us. Let's go down there while we're still young. Committee, we are back at 1:15. The chair is having a brain cramp, and I have 4 pink cards in front of me from Don McKinney, Bill Woods, Richard Head, and Fran Nutter Upham. If you filled out a pink card and are not any of those 4 people, I have managed to lose it, and you can fill out another one. Yeah, I don't think I lost hers yet because I haven't had a chance to, okay? But I will, given the opportunity. Thank you. Open the hearing on House Bill 306 relative to prohibiting reunification therapy. The chair recognizes Representative Fran Nutter Upham to present the bill.
Thank you, Mr. Chairman. So I am Fran Nutter Upham. I have a master's in counseling. I have been a licensed clinical mental health counselor. I got my license in 2005. I let it drop in 15 because I was doing other work. And this morning I turned in the rest of my papers to get reinstated. So I have expertise in diagnosing and treating several different, ailments, I guess we'll call it. I'm also an art therapist. More of you know of me in that venue. I've worked in private practice, inpatient mental hospitals, outplacement agencies where we went out into the community to treat children. This bill, it's a little hard to get a handle on because people are going, well, what is reunification therapy? It sounds nice. You're trying to reunite people. But apparently it comes out of someone's work. It's not a valid therapy. It is not paid for by insurances because it is not a valid therapy. And it has something to do with abused children who do not want to see their parent who abused them, and the court ordering that they have some kind of therapy with that parent who abused them. Because it is not a sanctioned therapy, of course, it is not paid for by insurance. So whichever parent the court would then order to pay for this therapy, it would be out of pocket and at great expense. I think the bill needs a little more work, and I think the bill needs buy-in from several of the agencies, legal, DCYF, Waypoint, that would have expert knowledge in dealing with the courts and dealing with children who have experienced some of these things. So I have a brief thing I wanted to read you. I know you have received information and testimony. So a retired lawyer, Paula Worm, I'm just going to read like 2 short paragraphs. She says, as a former family law attorney who concentrated on child abuse and neglect law, I became educated about systematic structural problems towards the end of my career impacting the health and well-being of families in the child custody and child abuse and domestic violence cases. This paper is an outgrowth of months of hands-on courthouse research. I concentrated my efforts on the complex case docket and other cases in the Seacoast area. And she has a brief paragraph that she says, reunification therapy. It said, reunification therapy is not a therapy because it isn't covered by health insurance, and it's not a real therapy. It is unethical for a psychologist, and I would also say psychiatrist or psychotherapist or a social worker to participate in it. Judges are ordering it to the tune of $100,000 or more and demanding that protective parents borrow the funds to pay for it. Grandparents of New Hampshire children have taken out second mortgages on homes to pay for it. It is one thing to order therapy in a child abuse or neglect case where the judge has founded a complaint and there is a duty under federal law to attempt to reunify parent and child. But to order reunification therapy when they have the power to condition child contact on a parent addressing their bad behavior is beyond the pale. It is almost exclusively, oh, all right, then it goes on. So what I would request from you today, which is maybe a little unusual for someone introducing a bill, is that you retain this bill so that I can, and I'm willing to work on it in the fall. People have already approached me about they would like to give their input to form a better bill that we can define the terms that we need to define so that this is a clear bill and that we can make an airtight case against reunification therapy and maybe inform the courts about what is appropriate therapy in this case. If they felt erringly perhaps that this was a tool that was innocuous or helpful, perhaps they didn't understand it is not. And I'd be happy to take questions or comments.
I think you know from our work in Health and Human Services together last term that one of my day jobs is to be part-time CEO of a medical and counseling center. And one of the things I ask when I go to hire potential new counselors to join my staff is, are you licensed? Are the people who practice reunification therapy licensed? Are they required to be licensed in the state of New Hampshire?
Her testimony goes on to say that there are some social workers that participate in this, which I find a little hard to believe. So I think if we stick with the line that you need a licensed therapist of any kind would not participate in this form of therapy because it's not a real form of therapy.
And how does one determine what is a real form of therapy?
That's an excellent question.
I thought so.
And I have a stack of papers like this, articles about this, whatever. So it could be based on something called alienation syndrome, which apparently is not listed in the DMS.
Yes.
Yeah.
Yeah, I
So
looked in
that's-
DSM and I couldn't find it.
Right.
Yeah.
So if you were to treat a disorder, the disorder would be in the diagnostic
Statistical Manual of Mental
of
Disorders. Yeah.
Right. It's our therapy Bible that we can look everything up. It doesn't give the treatment. That's another book. But so to be a valid disorder, it would have to be in the statistical manual. And then to treat that disorder, you would have to have a real disorder. You can't make one up and then make up your own therapy.
Follow-up question, there are all kinds of stuff out there. Somebody comes up with something and sells it on TV. Is this reunification therapy acknowledged by any of the professional associations of psychiatry or psychology nationally?
As a valid therapy?
As a valid therapy?
I believe not.
Okay. Okay. Any further questions for the prime sponsor? I don't see any. And your testimony included the statement that there are people who would like to work with you. They don't have to wait until the fall. Any citizen can work with you further if you wish. You mentioned that, so it is your hope that this committee would retain the bill for further work.
Right, because with the support of this committee to name a time and a place where we could meet, and notice that we were meeting, we may get some shareholders in that I might not otherwise know how to contact.
You will recall the way I worked at Health and Human Services Committee was any group of people with a couple of reps. You know, we're not going to violate 91A. We're not going to have 51% of the committee, but we could grab a couple of reps and then anybody from the department, from this association, that, whatever, and spend a lot of time hanging out doing things so that when we come to the fall and take a retained bill off the table and look at it again, a lot of work has been done prior to that.
I am more than willing to
That's
facilitate
what
that.
worked, as you recall. We didn't do work groups in the traditional way. We did them a different way, and I think it had some success.
I believe so.
Okay, thank you. I see no further
Oh, yeah,
except for one.
Except for one, Representative Ball.
Representative Ball.
Thank you, Chairman. Just a point of clarification for me because I'm taking the notes. The alienation syndrome, did you said that is not in the DSM?
It is not.
Okay, I just wanted to make sure I had that correct. Thank you.
Thank you.
Representative Moulton.
Thank you, Mr. Chairman. So is reunification therapy being ordered in the state of New Hampshire?
It is.
So what do they do? Is it just psychotherapy?
Well, it can't be psychotherapy because it would be illegal.
But they have to be doing something if it's ordered. So what are they doing for therapy?
It's non-licensed people who are doing, and I'd like more information about what exactly. So it can't be a licensed person because it wouldn't be covered by insurance, and it wouldn't be ethical for their discipline to engage in a therapy that is not a valid therapy. So it would have to be somebody who says, I do reunification therapy without, I don't know what kind of training.
Okay, so you're not sure how they're currently treating it, but we know that it's being ordered.
Yes.
Okay, thank you.
Thank you.
Representative DeSimone.
Thank you, Mr. Chairman, and thank you for taking my question. My question is that if a judge were to take the word reunification out and just state that the family needed to enter into therapy, could it be during that therapeutic time that the therapist would couldn't it be true that the therapist would gear toward reunifying the family unit without using the reunification?
And I think it's appropriate sometimes for courts to say, I think we need therapy to see what we can do with this family. I would just be comfortable that it's a licensed therapist who's working to, I wish I could find to put the family back together if that's possible. But the reunification therapy is always with a case of abuse. And like, how far do you push a child to have to be in the presence of someone who abused them? I mean, I quit a job a few years ago over a salary dispute, and I never want to see my manager again. And and that's trivial compared to what some of these children would have been through. And so, I'm kind of Pollyanna-ish. I'd like to think that professional licensed therapists would do whatever is in the best interest of the child, and not to have the court order, we want type A therapy. Just the blanket, this family needs therapy, that's appropriate. But to pick which kind and who they need to go to and how to pay out of pocket is not appropriate, as we did pass House Bill 200 about judges ordering therapy has to be within a parent's insurance plan. And that's fair. So, yeah, we're not ready to put microphones inside of the therapy offices to know exactly the nuances of everything that goes on. But I like to trust in my profession that qualified licensed therapists are doing a good job. I'd like to also think that judges are honest and doing their best job, but maybe in this case, maybe a little misinformed about what's going on. Thank you.
Seeing no further questions, thank you, Representative, for introducing your bill. I now have a handful of pink cards, roughly divided pro and con. And for everyone now, we are under our 3-minute rule. If you have a story to tell, give the highlights. If you have papers to give to us, please present them over in the corner before you come up. And I'd like to now call upon Dawn McKenney from New Hampshire Legal Assistance.
The policy director at New Hampshire Legal Assistance. You're going to hear from much more expert folks after me, I believe, but we support the idea of retaining the bill and working on another, some additional revisions or language. We do not support reunification therapy. We think, though, that this bill also would not prevent the use of reunification therapy as currently drafted. So we're interested in working on, with the sponsor, on drafting and clarifying some of the language and getting buy-in from the courts, et cetera, to make sure that it can be implemented as well. So with that.
Thank you.
Yep.
Wow, I owe you 2 minutes next time. The chair recognizes, it looks like Bill Woolsey. That's what I can read. If that's different, let me know. How'd I do?
My handwriting is bad.
I got Bill.
Yes.
Sir.
Good afternoon, members of the committee. Thank you very much for allowing me to speak today. My name is Bill Woodbury.
Oh. This doesn't count against your time.
Okay.
Okay, go.
My name is Bill Woodbury, and I'm an attorney practicing in Laconia, practicing primarily family law, and although I do other things. And I am I'm a past president and current legislative chair for New Hampshire Association for Justice. And we're here in opposition to this bill. We believe that where it is our job to kind of look out for things that deny access to justice, that this is an issue of that nature, in that it is taking away an important tool in the judicial toolbox. And I don't know that, I mean, in the 19 years that I've been doing family law, I have not seen the reunification theory as presented occurring. I'm not saying it isn't. I practice in a specific part of the state, but I think that what the prime sponsor said is absolutely true. That there needs to be a more specific definition of what is being discussed here. I think it was Representative DeSimone that kind of hit upon the fact that there's any number of things that could be ordered by the court that could fall under the umbrella of reunification therapy. There's any number of situations, a vast number of situations in different types of cases, abuse, neglect, divorce, post-divorce, where the court could see it as in the best interest of the child, as is their mandate. It is under 461A, is the policy of the state to ensure that both parents have a relationship and contact with the child, as long as it's in that child's best interest. So I think that in the absence of a firm definition of what constitutes reunification therapy, that and the fact that as to the other parts of this, that the judges, I think, always try to make sure that there's ability to pay, insurance, agreement between the parties as to who is going to be approached for therapy. In my experience, the judges go a long way to try and make sure that they're not going to order something that's impossible. That would be against their mandate as well. They're not going to order something that somebody simply can't do financially or otherwise. So I think this bill, it's kind of asking for something that's exceedingly vague right now, and we oppose it. I'm happy to answer any questions.
Representative Nelson.
Thank you, Mr. Chairman, and thank you for taking my call. I'm wondering if you could please provide a couple of, general examples of situations, family situations where reunification therapy would have been administered.
Well, again, not knowing the exact definition that the prime sponsor described, something costing hundreds of thousands of dollars or anything like that, but the need to have therapy to promote reunification could happen after a period of a parent being in prison. Could happen after a period of a parent being in rehab for substance abuse. It could have absolutely nothing to do with abuse or anything like that. It could happen after there was a finding of abuse, with therapy, that parent proves to the court that they have the ability to go forward with a relationship with a child that is no longer detrimental to that child. Sorry. There are any number of situations that you can imagine where there's an interruption in that relationship between a parent and child for whatever reason, and the court's always going to be asking the question in the first instance: is it in the best interest of the child to reunify with this parent? And if it is not, there'll be, an alternative solution suggested. But therapy is a crucial tool, and again, many things would fall under that umbrella of reunification therapy.
Any further questions? Seeing none, thank you,
Thank you to the
Councilor, for
committee.
coming today. The chair recognizes, it's either John DeJoy or Dajouet. Well, it could be, it's French. From the National Association of Social Workers, New Hampshire Psychological Association. How do you pronounce it?
DeJoy.
Welcome to America. Many generations ago, I'm sure.
Many generations ago. Mr. Chairman, members of the committee, thank you very much for your time. My clients, the New Hampshire Association, the National Association of Social Workers, is a nationwide membership group for social workers across the country. I represent the New Hampshire chapter, which has more than 700 members who are all social workers in New Hampshire. New Hampshire Psychological Association, similarly, is a national organization. I represent the New Hampshire chapter, which works with New Hampshire doctoral level and school psychologists. Neither of my clients have a position on this bill. I had no intention of testifying. I'd just like to provide a little bit of context regarding what is referred to as reunification therapy. I think what the sponsor was trying to say at the beginning, and not to put words in her mouth, this is not an evidence-based practice. Evidence-based practice is the gold standard of any kind of therapeutic intervention. What an evidence-based practice requires is research that confirms the efficacy and the outcomes of any intervention. Reunification therapy broadly is not an accepted intervention by any national mental health or psychological organization. It has, in fact, been researched since the mid-'80s. It was originally referred to as parental alienation syndrome. It is now simply referred to as parental alienation. It is not a syndrome officially. It is also not in the DSM-5, which is the Diagnostic and Statistical Manual for mental illness that is used by most psychotherapists. This, in all cases, is when it's been ordered relative to divorce disputes, where one parent has accused another parent of saying bad things, my word, and alienating that child from the parent. The position of both of my clients, very simply, is that there is no such thing as reunification therapy. And with due respect to the court, we respect the court's need for assessments and therapeutic intervention and think that's appropriate in any instance that the judge believes it's appropriate. However, my clients do not believe a judge should be ordering reunification therapy any more than they should order CBT, DBT, psychoanalysis, or any other evidence-based practice. If a judge has a need for an assessment, that is an appropriate order, and they may even order the therapist to assess the ability of the family to reunify. That's appropriate. It's also appropriate to provide therapeutic intervention. In that case, though, licensed therapists in all instances take their lead from what the clients, whether that's an individual or a family, what the clients seek to achieve. If a client seeks to reunify their family, that can be an appropriate therapeutic approach if everyone in the family is in agreement. So with that, I'll leave it at that, but we just simply wanted to provide context that this is not a recognized practice, nor is it an evidence-based practice, and we would strongly request, with all due respect of the court, to order an assessment or therapy, as opposed to identify the intervention and permit the licensed therapist to determine which is the most appropriate intervention given the needs of that family.
Thank you so much, sir. You mentioned that something was studied in the 80s. You used the term parental alienation. Was reunification therapy itself ever studied by outside groups looking at it?
It has been studied intermittently in the literature. When I reference parental alienation syndrome, that was and I apologize, I do not have the researcher's name. Reunification therapy was a direct outgrowth of parental alienation syndrome. And this researcher theorized that therapy to reunify the family was a way to address parental alienation syndrome. Since 1980, however many decades that is, my math is failing me today. Since that, there have been intermittent efforts, but most of the literature talks about what I spoke about today, that reunification therapy is not a recognized therapy, nor is it evidence-based. Some researchers refer to it as pseudoscience. Others simply say it is not, it doesn't have a body of knowledge that recognizes the efficacy or the positive outcomes of any intervention of that sort.
Thank you. Any further questions for Mr. DeJoy? Representative Raymond.
Thank you. And thank you, Mr. DeJoy, for taking my question. You had said that your clients, which are a psychological association nationally and the New Hampshire chapter, and then the Association of Social Workers nationally and the New Hampshire chapter, would ask judges to order an assessment and therapy if appropriate. Would your clients also want that to say, like, by a licensed mental health counselor or a mental health counselor licensed by the state of New Hampshire, or something there to indicate that it is, in fact, someone who has been licensed and is overseen, as opposed to just any person calling themselves a counselor?
Thank you very much for the question, Representative. And just for clarity, I represent the New Hampshire chapters of both organizations.
Okay.
There is a national organization as well that I do not represent.
Okay, thank you for clarifying.
So I have not had that conversation with my client directly, and I'm losing my train of thought. Can you repeat the question?
That's okay. My question was, instead of ordering a particular type of counseling or therapy, would your associations want judges to, or even have a law that said judges are to order
licensed,
assessment and appropriate therapy by a licensed, counselor or mental health therapist?
That's a great question. We believe that interventions of that level ought to be licensed, but we have a licensing scheme in this state that requires social workers identifying themselves in certain ways to be licensed, as well as psychologists to be licensed. I'll leave that to you folks in EDNA. I would hope that the court, and I believe the courts are, using due diligence if they assign someone to assess, and that they are using licensed therapists. I don't know that, but that would be my expectation.
Thank you.
Representative Bickford.
Thank you, Mr. Chairman. The researcher you spoke of in 1980s on alienation, was that Dr. Richard Gardner?
I can find out, Representative, and get back to you.
It's the only one I know of. That
It probably is then, but I don't have the name. But I'd be happy to get it and send it to you, or send it to the whole committee if you'd like.
Thank you.
Thank you, sir.
Thank you.
Chair recognizes Attorney Richard Head from the Judicial Branch.
Hopefully I have enough copies of what I'm handing out. If not, I have some extras. Um, I'm happy to begin. For the record, my name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. What I'm handing out is written testimony from Judge Jennifer Lemire, who apologizes, was unable to make it today. She had to be on the bench. If you don't have enough copies, I do have some extras I can hand out. And what is contained in Judge Lemire's testimony is sort of in very general terms what it is and how she uses counseling, which is broadly described as reunification counseling. At the end of the day, we do support having this bill retained. We think as written, it is very broad and could encompass a great deal more than perhaps even than what was intended in terms of the scope of it. And in general, as the sponsor had identified reunification therapy as being used in abuse and neglect situations. And the reality is it is considered in a much broader set of circumstances where there's been a long period of separation between a parent and a child, whether it be by imprisonment, by some mental health issues that have caused a parent not to participate with a child, whether it be a whole host of potential reasons why there's been a period of separation between a parent and a child. And that child may very well have no memory of that parent or have no impression of that parent and have no interest in having that parent participate in their lives. And the reality is, though, as a judge, they have constitutional and statutory obligations relative to both parents having a role in that child's life. And as Judge Lemire explains in her written testimony, during the course of a proceeding, she may not have, or a judge may not have sufficient information to know what is the cause of the child's resistance to a parent and what is driving that, and whether or not it is abuse and fear, which is legitimate and has to be accounted for in terms of whether that parent does have a role, but also just is it time that has led that child to have no interest in a relationship? Is it another parent that is causing information to go to that child that is causing that child to resist wanting the other parent involved? And as she describes in her testimony, when she believes that additional counseling is appropriate and necessary, given the lack of sort of information available to her, and she's ordering counseling, she does not simply order reunification therapy. She talks to the parties about it because there has to be buy-in from the parties. In identifying the counselor, she will ask frequently the counselors already involved don't have either the skill or the interest in bringing in what is necessary for this type of counseling, which is both parents, the child, in working with them as a group at times. So she does ask the parents to solicit recommendations of who could be the counselor in a reunification setting. She would take those names if they, and frequently the parties agree to who would be that counselor. If they don't, she asks for names that would come from sources, preferably from existing counselors already involved in counseling the parties, whether it be the parents or the child. But at the end of the day, what is concerning about the bill is its breadth would eliminate all sort of counseling and therapy that relates to the reunification of a child who is resisting a particular parent for a reason that may not be abuse. It may be time. It may be, whatever it may be. There's just almost an unlimited number of fact circumstances that can lead a child to resist. And if there is an opportunity to bring that family unit together, and at least as Judge Lemire points out, it has been successful in cases. It is a tool that is available, and we feel that simply eliminating an entire category without more detail and specifics can lead to some unintended consequences. So we do support. We would be happy to participate with the chair, whether it be in a retained committee hearing or just with the sponsor and the parties to work through exactly what is intended, what is the aspect of this that there's opposition, and where in fact it can be useful. So we oppose the bill as written. We would be happy to participate if the bill is retained. It is a bill that seems to come up every year and fail every year. So if there's a specific aspect of this that is the target, then we'd be happy to work with the committee and the sponsor to try to identify that. But at least as written, it would eliminate a tool that does get used and has been used successfully in the court system. It is an area, I will confess, I'm not at all an expert in. So if you have questions, I'd be happy to try to answer them, but I may have to defer. But with that, I'll conclude my comments, but I'd be happy to attempt to answer any
Chair
questions.
recognizes Representative McMahon.
Thank you, Mr. Chairman. Attorney Head, on the document passed out from Judge Lemire on page 4, it refers in the third paragraph down of to allow the entities to participate in counseling, and then it refers to a colleague calling it reunification therapy. As already heard, that reunification therapy does not exist as a professional designation. Would the elimination of that in the review of the bill make this a more appropriate act?
So I think the real question is, whatever we call it, we have to explain what that is. And that's why you'll see in Judge Lemire's letter, reunification therapy being used in quotes. And the reality is, as she said, she wasn't sure what the scope was of the intent of the bill. And in that kind of ambiguity, we may lose an important tool that, in fact, people agree is useful. So I may not have answered your question, but I'm not sure just changing the word would cure the potential issue.
One follow-up, Mr. Chairman?
Yes,
Thank you.
follow-up.
Thank you, sir. Attorney, then, specific to the bill, and I'm in favor of retaining this, was where it states on line 5, was recommended by parties that a participating provider in the party's health insurance carrier. It's the next sentence that's caused a concern, and that's the identifier of reunification therapy, again, as an entity. What would be your guidance on that?
So thank you for the question. I think there are instances where you can have it a counselor recommended by the parties, and they're not a participating provider, but the parties are willing and have the ability to pay. And as Judge Lemire said, insurance, if there is insurance, that's obviously the best, but there are instances where there is not insurance available for whatever reason, but the parties have a willingness and an ability to pay, and the ability to pay is a part of her evaluation. And if the parties do not have that ability to pay, She does not order it. And she has financial statements. She has information available to her to make that determination. So I would say simply saying all counseling services have to be covered by an insurance, and that provider has to be covered by the insurance may be too restrictive if you make it a flat obligation.
Okay, thank you, sir. Thank you, Mr. Chairman.
Representative Raymond.
Thank you, Mr. Chairman, and thank you, Attorney Head, for coming and answering our questions. It seems to me that there is some tension and conflict between different parties using the same phrase to mean different things. So it sounds like judges are using reunification therapy as kind of a catch-all generic term referring to a various list of modalities of therapy that could lead to a family reunifying, which is the mandate, frankly, in a DCYF case. As we move through, there's a mandate to try and reunify within 12 months. So I guess my question is then, now that we are learning through this process that there is something that is a questionable practice called reunification therapy, is it possible to have advice or a judicial note or guidelines for our judges to not use that term because it is so easily confused with a treatment modality that is not evidence-based, and instead ask judges to refrain from using the term reunification therapy and use instead something that is more clinically appropriate, such as assessment and therapeutic intervention if warranted? Or I'm not an attorney, so crafting that would be better, but to consciously have judge consciously avoid using a term that is also the name of a very specific non-evidence-based treatment modality. Just like they wouldn't order, CBC therapy or, dialectic behavioral therapy, because that's not in their purview.
So thank you for the question. I think in part the answer is yes, but in part the concern would still be if a bill is passed that prohibits quote unquote reunification therapy without defining that, the scope of that could include anything that where the reunification of the parties is. I mean, it's such a basic word and doesn't seem to have a certainly within the bill, a definition of what is being included in that term, that even if we did go ahead and have guidance and a process where the term reunification therapy was not used, it may still be considered within the scope of that if we have a flat out legislative prohibition on this type of counseling.
Thank you.
So, and again, that just leads to, given that this is a bill that comes up on a regular basis, it would help to retain it and see if there is a way of putting that, those two pieces as you described together that don't conflict with one another.
Thank you, Counselor.
Thank you.
The chair recognizes Gail Drobat.
Mr. Chair,
Yes.
I just want to take a moment and apologize to all the members of the committee and people on the public. If you see me sitting and walking away and all that, I have someone who it was very close into my heart. It was someone who, it was like my supporter person when I moved here, passed away last night.
Oh, we're sorry. We're sorry.
It's been one of those toughest days that I wish I can be in Virginia with my extended family, but I'm grateful to be here. And yeah, and I'm so sorry that I'm walking back and forth, but I just try to take it all in.
Do whatever you need, Representative. We're with you.
Thank you.
You're welcome.
Thank you.
You
Mr.
asked for 1 minute and we're getting overtime, so we'll
I
give
put
you.
1 minute. I need more than that.
Well, we'll give you 3 and then the mic disappears.
I might need more than that too.
Well, you're not going to get it.
Thank you, Mr. Chairman, members of the committee, for letting me testify today. My name is Gail Drobat. I'm from Amherst, New Hampshire. I am a mom that has never been involved in the family court, but this has come up a lot with the reunification from parents I've talked to. I'm going to talk about one specific case without any names, and I'm going to give you this information after, but the family was ordered to have the child engage with an individual therapist for the child to speak about his feelings. The therapist allowed mom in those sessions, gave dad minimal information. She said she saw him twice and told dad that it would take several more sessions for him to be comfortable to open up, and then she wrote a bad report about dad. She recommended a reunification therapist 2 doors down in her same building, so you can imagine dad's reluctance. Once asked what he would do to assess, diagnose, and treat this situation, he declined service. So this child hasn't seen his father in 5 years, or any other member of his father's family. So the court orders another reunification therapist, recommended by a longstanding bar member who they won't release the name of. He contacted her on November 2nd, no response. November 19th, no response. December 20th, she responded the 29th of December, 2021. She said, in response to your inquiry about reunification counseling, I'm attaching my copy of my service agreement. And get back to me. January 21st, 2022, he says, when's the soonest you can see us? January 24th, to the extent I received from you and the other party, I unfortunately do not expect to have any availability for several months, after she told the court she would take this case. Then again on April 22nd, he said, my son and I were court ordered to engage with you. What's your earliest appointment? No response. The parties go to court. Mom has been in contact with the therapist, and she says, thank you. Hold on here. I don't have that part. Anyway, he contacts her again on April 10th. Again, my son and I with the court therapy. On April 14th, she says, I received your email regarding court-ordered family therapy. Unfortunately, my practice is full. 5 years, this child has not seen his father. And for the court to keep going this, and dad has made multiple motions to have it referred to other therapists, denied, denied, denied. So my request to you all, and we just heard that reunification isn't a therapy. And
You've got half a minute.
I'm going to
wrap
give you
it up.
this after. So I think court ordered therapy involved in family court systems need to be done with a clinical psychologist with a minimal of family systems therapy to figure out the breakdown of the family. These kids cannot go weeks, months, years without seeing both parents. If there is an attachment pathology, you better get it fixed quickly because you're ruining the lives of these children.
May we ask you a question?
You sure can.
My question is this: if there was a licensed in the state of New Hampshire therapist of some type, and this push, and ignore took place, there is a board where a complaint may be filed.
Oh, well.
Where is the board for unification therapy?
the mental health board, and a complaint was filed, and there was no wrongdoing found. There was a complaint to the JCC, no wrongdoing found. There was a complaint to the Attorney Discipline Office, no finding. And we'll talk about that on another bill, but I think we really need to sit down with all parties and the judiciary and figure out something for these kids, because at the end of the day, the kids are the ones being abused, and it's got to stop. They're our future.
Does anyone else have any questions besides me, Representative Petrino?
Thank you, Chairman, and thank you for taking my question. I'm just a little bit confused, so I just need some clarification.
Sure.
The bill we're looking at prohibits the use of reunification therapy, but the situation that you explained was that this individual was trying to get reunification therapy for 5 years or more,
No, he-
ordered by the courts, and could not make this happen.
Right.
So I'm just confused. It sounds like reunification therapy was something that was welcomed, but this bill says that we should prohibit it, and that's where I'm confused.
The court ordered it. I think it should be prohibited. It doesn't address, well, it's a non-established therapy, first off. So they need to address the why the child has an attachment pathology. Why is it rejecting a parent? You know, and that should be done immediately. If they're going into family court and a child's rejecting a parent, you better find out why quickly, because either the parent that has the child is abusing them psychologically and keeping them away from one parent, or the other parent has abused them. So either way, you better do something quick. And this is 5 years. Thank you for your question.
Thank you for your testimony. The chair calls Kathy Jones from Plastow. I used to represent Plastow for 6 years. Mother Justice Network. I'm intrigued about that since it was in my district at one point.
Well, thank you. And thank you for having me here today.
Oh, excuse me. Would the previous do what she's doing? Hand in her written testimony. Thank you. Sorry.
It's okay. So thank you for allowing me to be here today. I do have written testimony, but every time I hear somebody else say something, the thoughts in my head change. So I'm going to do this as best as I can and as quickly as I can. My name is Kathy Jones. I'm with Mother Justice Network. I do not have a string of letters after my name, but I have 25 years in the business of domestic violence. I'm a national expert on domestic violence. And the reason I'm here today is because high conflict family court cases is equal to domestic violence related cases. They are one and the same. And in a vast majority of these types of cases that end up in family court, which is different from child protection court, and I understand that child protection has its uses for reunification, but I'm specifically here to talk about family court and reunification therapies today. There is so much damage being done across the state by courts who are ordering children to be forced into reunification therapies with parents who are abusive not only to the children themselves, but also to their former intimate partner, which is creating just havoc and chaos, both for the families individually, but for the court systems themselves, who are overwhelmed by these high conflict cases that keep coming back in, because there is no end in sight. Divorce is an industry. It's a $50 billion industry in the country. And reunification therapy, I feel like, is responsible for at least half of it. There is no regulation. Practitioners can charge whatever the heck they want. It's all out of pocket paid. And this is money that should be going for better things like child support and actually helping the individuals and the families involved. In 2018 and 2019, I don't know, I'm sorry, I forgot to say, I'm a completely unfunded program, by the way. And my entire life is devoted to protective parents who are trying to keep their children safe through the family court system.
You've got 1 minute.
Okay. In 2018 and 2019, I'd put together a support group for protective parents who are trying to deal with the fact that their children were becoming suicidal because of their reunification therapies that they were being forced into. These reunification therapists were denying their children's experiences, were threatening the children, were basically bullying these children into having contact with family members that frightened these children. Right now, I'm dealing with a mother somewhere midpoint in our state whose ex was actually convicted of and spent time in jail for raping her. And she has been recently notified that the judge in her case is going to be forcing her children into reunification therapy with the father, even though he admitted in family court to humping the children. Yes, ma'am. And this is the type of stuff that I deal with day in and day out. I am exhausted by being a one-person practitioner who is dealing with the dregs of what happens when these family court systems get this issue wrong.
Thank you for your testimony. I will ask if anyone has any questions, in which case, thank you for your testimony.
just say one last thing? Just
you
one last
have
thing.
30 seconds,
Thank
then
you.
that's it.
The reason there's a difference between DCYF and family court is because DCYF, as imperfect as that system may be, they have experts in domestic violence that are embedded within their systems that can at least consult with them and give them guidance as what to do. The family courts do not utilize such experts, and mental health practitioners and any other professional out there are not experts in domestic and family violence.
Thank
And
you
that
so
is
much.
a key problem.
Thank you so much. Now we have one more, and this will be the last card I will receive on this, and this is Betty Gay, and you will be held to strict 3 minutes. For someone from Houston, you can talk quick. Representative Gay is late of this committee and had represented Plastow and Atkinson for a while. Representative Gay. Turn it on. Thank you.
Okay. To be fast, I made some points how reunification therapy gets ordered. Person files for divorce and alleges domestic violence. They automatically are referred to a high conflict court. GALs are assigned to the children. The parents do not get to choose the GALs. The GAL asks the children if they want to be with both parents. This assessment can take all of 15 minutes. The GAL recommends the children be ordered to reunification therapy with or without the parent that they don't want to see, if the children are reluctant to see one of the parents. The parents have no choice of the counselor. The parent is told that if they don't take the children, that parent will lose custody. It is an absolute threat. The parent takes the child. They pay 100%, $150 an hour to anywhere as high as $350 an hour. There's no assessment of charge. There's no assessment of cause. Part of reunification therapy, as you will see in this notice, an email from a physician, from an attorney, family attorney, mentioning the training for the attorneys. Our attorneys here get this training, and they are taught that this is greater than sliced bread. The parent takes the child. There's no assessment of cause. The child has been subjected to threats by the counselor, by the reunification therapy counselor. The child is told, if you don't get with the program, we are going to make you live with this parent you don't want to be with. I'm sure there's more to that, but that's a good basic. Okay, what I just referred to.
Got a minute and 15.
Okay, you will see on this letter that, as you can see, special attention is given to ensuring the child in question. This is training for attorneys. As you can see in RT, the child in question is not given an opportunity to validate his or her fears of the allegedly abusive parent, nor to express grievances against that parent. I know this lawyer who wrote it is aware of published critiques of approaches to such cases based on PAS and its affiliated theories, possibly my own work, but it's nevertheless confidently telling lawyers to ignore the child's perspective. So therein lies the absolute cruelty of this practice. It doesn't matter what the child feels, but so many people are making their livings on this whole system. To change it, it's like digging out a mountain with a tablespoon. But I have confidence that there are so many caring people here that we can start turning this around.
Thank you, Representative. Do you have handouts you'd like us to read? My plan is to exec this bill on the 21st, 2 weeks from today.
I received these documents, but I have no idea who they are from.
Did you receive them today?
Just now from Bigfoot.
We received some documents here, and this is me speaking now. I'm not likely to take them seriously. They're not identified as to who they came from. And that is probably just an oversight on your part. In a minute here in the break between this bill and the next one, if you could sign in, that would really make me feel great. Thank you. So with that, I am closing the hearing on House Bill 306. And if a group of you want to get together over the summer and work on this, and eventually we will take it off the table, that's fine. My suggestion to you, as it is to everyone, when assertions are made, I want to see footnotes. I want to see documentation. If there are people who said that, I would like, to the degree that they are willing to give their names, which adds to their credibility, we would do that. Yeah, they put themselves at a bit of a risk to do that, but I want to be able to take them seriously. And if there's cases of we spent $100,000, prove your case, is what I'm saying. Find a good balanced position, define your terms, prove your case. So then when it comes back here in the fall, we'll have something more substantial to work on. So thank you so much. All right, we're going to take about a 5-minute recess while we regroup. And all these nice papers that Representative Gay has given us are duly filed away. Approach, yeah. Also, this is for the committee, the email, the printout that Attorney Head handed out has a typo on the front that may confuse you. This is House Bill 306, not 603. 603 is where we live. 306 is the bill. Change it so it doesn't get misfiled. As a friend of mine says, he's not dyslexic, he's less dixic.
Oh, thank you. I appreciate it. Representative
Mr. Chairman. I'm just wondering, are we executing any other bills today?
Opening the hearing on House Bill 490, an act relative to modifying the definition of neglect. The chair recognizes Representative Corcoran to present his bill.
In the form of.
I feel I've been neglected. The chair recognizes the alderman from Manchester, the vice chairman and ranking member of this committee, the Honorable Patrick Long.
Oh, thank you, Mr. Chairman.
Yeah.
I'll introduce House Bill 490 relative to modifying the definition of neglect.
This never happened in Health and Human Services. Take a minute to read it over. I hate to beg for people to fill out pink cards. Representative Moulton, are you multitasking by reading the bill while talking with your friends?
Yes, I am.
I
I'm very
bet
good
you
at
are.
multitasking. I'm very good at multitasking.
That's all I wanted was a straight answer.
Spoken like a classroom teacher, huh?
Yes.
As I said earlier today, this is the rowdy section.
I'm disappointed. It was my intent to make this entire committee that. I'm going back to Health and Human Services if you insist on being so serious. Thank you. Here they go. Okay, let's turn our fun to the bill in front of us. Over there, RS, rowdy section. And what do you think about the bill? Representative Gregg, what do you think about the bill? After you've turned your mic on.
All right. Here I was thinking I wasn't rowdy, and I'm like full on rowdy called out.
You were not called out, you were selected.
Aw, that sounds so much better. So I think this, I just think the language, we're just discussing, right? I
Can I
don't
get a
have to
point
ask
of
a
order?
question.
Point of order.
Should we do have somebody signed up to speak on the bill? So prior to discussion, should
Oh,
we
this is
have
true.
somebody speak?
You do have a card?
I have a card. She's so patient over there. The chair recognizes from DCYFESQ, Beth Murchison, who actually has been sitting there waiting for sanity to break out.
And at last it has.
All kidding aside, thank you, Mr. Chair, Vice Chair, and other members of the committee. So the division it appreciates the opportunity to speak on this bill. In general, the division is not in favor of modifying the definition of neglect. Neglect is a very fact-specific, case-specific situation, and the enumeration of sort of activities under this legislation would make that very, very complicated for the division. That said, we generally sort of review this suggested language change as sort of the free range child kind of provision. And in general, I mean, the division does not file for neglect on free range children. So we just wanted to appreciate the opportunity to share our thoughts with the committee on this bill. Thank you. I'm happy to take any questions if anyone has any.
Would you define free range child? You know one when you see one, right?
If it walks like a duck, quacks like a duck, no. Free range child is one who's given a certain amount of independence by their parents, depending on their maturity and their sort of capabilities. I think New Hampshire has a sort of a nice, I mean, I'm from New Jersey, and I think New Hampshire has a nice sort of tradition of that. And I think it makes for healthy, this is me talking, but I think that it does make for healthy development for children. That's generally what I think of as a free range child. So.
Follow-up question. Would you see this bill a solution looking for a problem? Is there a problem of inhibited free range children?
No, the division would say that we don't have a problem with that.
So you don't follow up to myself. You don't see that there's a bunch of kids that are really being trapped that could be able to walk to school because they're 17 or things like that.
Or drive to school because they're 17. I don't know. I don't know,
Okay.
Mr. Chair, to be completely honest.
Well, that's what I want.
Yeah,
Complete.
I don't think we see children who are not, allowed to do things that are developmentally appropriate. And so, but I really have no data on that. So.
Representative Raymond.
Thank you, Mr. Chairman, and thank you for speaking to us about this one. I know that other states have minimum ages for kids to do some of these things. Like Illinois, for example, wants kids to be like 13 before they're allowed to stay home alone. Does New Hampshire have any guidelines regarding ages for kids to stay home alone? One. And two, when DCYF receives a report of, say, an unintended child, what does the caseworker usually assess for when deciding whether or not it meets the statute?
I'm not aware that New Hampshire has minimum ages for anything, taking your first question first. As to the second question, if there was an assessment for an unattended child, we would certainly look to the age, the maturity, the circumstances. Is the child 12, left in a car while the parent ran in to get milk or something, and the general home environment.
Representative Levesque.
Thank you, Mr. Chair. Thank you for taking my question. Do you potentially see a problem with it being so vague on line 19 into 20 where it says remaining in a vehicle unattended, especially when we've seen like increases of over social media of people frantically trying to save children on hot vehicles during the summer, trying to break into them, police trying to break into vehicles. Do you see a problem with that line being so vague?
I think in general the language is problematic, although well intended. I think just because again our investigations are so fact and case specific. I think that if for some reason this was in our neglect statute, we would certainly, again, look to what Representative Raymond said. We would look to the circumstances surrounding the child remaining unattended in the vehicle. I don't know if that addresses your question. So,
no question. Representative Bickford.
Thank you, Mr. Chairman. I see this as more as language that parents are looking for to give them guidance as to what they may or may not do. Right now, they're in kind of a flux as to when they can leave their child unattended or go for a ride on the bicycle and such. I know times have changed somewhat. I know when I was a kid, which is just a little while ago, we thought nothing of jumping on our bicycles at 9 years old and going a mile down the road, because I lived in a rural area, or 2 miles down the road to visit a friend. But today you don't see too much of that anymore. I know my favorite show is Mayberry RFD, one of my favorite shows anyway. And you see Opie going off and doing things with his friends, and so I think parents are looking for some direction, and this might be something that might be helpful in that way.
I don't know, sir. I can't
Okay.
I can't presume to speak for parents in New Hampshire. So you know, I mean, we sort of. I mean, there's a scene in the movie E.T. about Elliot being left home alone when he was 9 years old, and so we were discussing this, like, you know, is that really problematic? You know, it's the E.T. Elliot kind of question, but you know, I think that it's up to parents' discretion, but I just cannot speak to what parents need in terms of direction.
I saw the movie Home Alone.
Yeah.
Is that-
Well, that probably would be problematic.
So
That was a
little-
mistake.
So little children going to the fishing hole, as in Mayberry RFD. Is anybody asserting we have an opioid crisis in this state?
Not that I'm aware of, sir.
Anyone else? Yeah, Representative Grossman.
Thank you, Mr. Chairman. And I wish that the representative who offered up this bill would be here to answer questions, because I'm confused about this lines 12 through 15 related to spiritual means, church, good faith. I mean,
That's already in there.
that is?
That's current law.
Yeah.
That is?
Mm-hmm.
Yeah.
Sorry.
But I agree with you.
Okay. All right, thank you.
This side of the room, take note of this, okay? All right, thank you. Representative Ball.
Thank you, Chairman. Thank you for taking my question. In reading this myself, as a person who apparently is a free-range child, or was raised a free-range child, it seems to be a societal change, because when I look at these activities, this is exactly what I did when I was 8, 9, 10 years old. And it was always my understanding, and correct me if I'm wrong, please, this would be my question, is that age 7 is the age of reason, which is why we allow children to walk to school when they're 7 in the first grade.
I don't
That-
know.
That is, and there's also there are also guidelines for babysitting as to when you can leave your child home alone and when they can take care of another person's child. So there are statutes, but yes, that's why children are not all bused. We do have walkers that go to elementary school. Thank you.
Anyone else? Thank you for your testimony.
Thank you very much.
In consultation with the vice chairman / ranking member, we are wondering if we are ready to exec this. Think so, everybody? Think we've all come to a conclusion pretty much, and it's the same conclusion? We're getting good at this one, you know. So I will close the hearing on House Bill 490 and open the exec session on House Bill 490, and the chair is looking for a motion. Representative Grossman, I withdraw my previous comment. It does not have to be in German when you write the blurb.
I'll make a motion for to move 490 ITL.
490 ITL, moved by Representative Grossman. Who is the second? Representative Nelson. We will make this bipartisan. Discussion. Representative DeSimone.
Thank you, Mr. Chair. It seems I was a free-range parent, and when my children got old enough, I actually called the state and said, if I let my child do this at this age and this and that at that age, am I neglecting my children? And they said, I was told, and I don't remember who it was, if you as a parent feel that your children can make those choices and are mature enough, then you as a parent make that choice. Now, the only one I ever had, so my children were on the weekends, yet they were allowed, after they got up and did their chores and had their breakfast, go outside and play and don't come back till lunch. And then at lunch, if they weren't fed outside, they were fed inside. Go outside and play and don't come back until the street lights were on, or come on. And the only one that ever said anything about that was my granddaughter, who said, Nan, you were so harsh. But I never had an issue with being charged with neglect or whatever. I kind of knew where my kids were. They were right in town and they did ride their bikes most a mile or whatever. I agree that this is a bill. It's looking for a problem, and most parents can make educated choices depending upon their child. Now, I should not have been left to run free, but my children were just fine.
Representative, you turned out okay. Representative Levesque.
I agree with Representative DeSimone. You know, there's a lot of schools where it's easily walkable for students. I went to a high school that was in another town and I had to drive there, but I would see students walking to there, and many of them were between the ages of 14 to 18, and that was perfectly okay because their houses were just down the street. You know, on the other hand, I don't think it'd be safe to walk down a highway or two to get to high school, but
125?
yes.
No.
Route 4 and 125, yeah.
Oh.
But I think that a lot of parents know what their children are capable of doing at certain ages. You know, they switch their car seats from facing backwards to frontwards after a certain age because of safety reasons. But, you know, I don't think that having such a vague law to dictate, oh, this is child abuse because they're riding their bikes to their friends, you know, they're going to a friend's. Most of the parents know that friends, they talk to the parents, they get to know their parents, you know, they intermingle, and I think that a lot of parents know what's best for their children, especially when it comes to like, hey, you can go over to little Susie's house, which is down the street.
And if they were doing something really wrong, a good faith complaint could be filed. See previous bill. Yeah. Anyone else? Representative Raymond waves off. Are you waving off? Or
No, I'd like to say
You're
something.
waving at me. Okay, yes,
Sorry,
Representative Raymond.
Sorry, I try and like lean forward and catch your attention because I'm in like the blind corner.
Your sincerity is much appreciated.
Thank you. Thank you for letting me speak. I think that it sounds, based on the nods and the smiles I'm seeing around this table, it sounds like we're pretty much in agreement as a committee, and I just think that's fantastic. New Hampshire has a great system of really trusting our families and our kids to really generally do the right thing. I do think there are situations where we've got, 2 and 3-year-olds who shouldn't be left home alone, and those parents need some education. But that's kind of what DCYF is for. That's why they send social workers out to help families when they have made a misstep. This language, I don't think adds anything to state law that isn't there, nor do I think it will change the practice of many families or our DCYF workers. So I don't see that it is helpful. So I support ITL.
Representative Moulton.
Thank you, Mr. Chairman. I actually like this amendment for the reasons what Representative Bickford had mentioned before, that it might provide guidance for parents whether they know that they can allow these activities. Because I too, like Representative DeSimone, have looked up like what can I allow like my child to do at what age? How old does my child have to be home alone type of things. I've looked those up as well. And so by giving the parents guidance, I think that's helpful. Also, I think it's helpful for people in the community to know that, this parent is not being neglectful, that, you see their kid outside and the parent's inside, and the kid is just playing and riding their bike around town, like they're not doing anything wrong. And so I think that the intent of this bill would be to drive down the number of calls to DCYF that, so-and-so in my town is, not watching their child because, I always see the child around without the parent. And those types of calls happen. So I think that there's actually good intent behind this language. The only thing that I see a problem with is the remaining in the vehicle unattended because of the hot weather. I would like to see that little phrase taken out, but all the rest of it, I don't see a problem with.
Representative Long.
Thank you, Mr. Chairman. The problem I see with this being put in statute is if a mature child is riding to their friend's house and something happens to them, do we go after the parent because they allowed him to do that? So when you put something in a statute saying that that is allowed, and something happens to the child, I mean, every child's different. Every parent's flexibility with what they'll allow their child to do is different. And that's the way I think it should remain, the way Ms. Marginson related it. First of all, she said there is no issue currently with this. So putting this in, I believe, would make it an issue.
My comment would be that if we went with this new language, I don't know if it would cut down the calls to DCYF because I don't know how many people read the RSAs of New Hampshire. So, I mean, what difference would it make? Anyone else? Yes, Representative Nelson.
I think that we don't even need to speculate about the intent of this bill because the sponsor isn't here. So I don't feel like we even need to be wasting our time speculating because we don't know why the sponsor desired to write this bill. Thank you.
Except when the sponsor's not here, we can speculate all we want and get away with it. Maybe that's not good, though. Probably not. Representative Bickford.
Excuse me. I wouldn't go there with the sponsor issue because he may have COVID for all we know, and it's in our possession now. But Representative Moulton brings up a good point, and I agree totally with this, and that's why I'm going with it. Is this will help limit reports, and we just heard a bill about how many reports that they get, and people wanting to go maliciously to prosecute people that may be doing false reporting. And they do get a lot of reports. Right now, people have to guess whether it's okay to do that or not. Representative DeSimone called DCYF, Representative Bolton called DCYF to get an opinion. We should have it in statute. And whether they read it or not, it doesn't matter. The word will get out from the statute. It's in writing now. It's not somebody's opinion over at DCYF. Then somebody else is going to have a different opinion, maybe. This is clear. And the word I like the most here is the word maturity. And we do use that in child law, family law.
The word what?
Maturity.
Maturity.
When you go to court, the court uses it too for a child to be able to testify. It depends on the maturity. When we talk about, slipped my mind now, there's something else though. But maturity is a key word here. And yes, as Representative Long says, well, it's somebody else's interpretation of that interpretation. But we should put it out there that this is our line that we're using, that an 11-year-old, sometimes very immature, that's the thing that DCYF would make the decisions on, whether they're immature or not, and the parents need to, from now on, keep track of that child more closely. So that's why I'm going to go with it, regardless of whether the sponsor's here or not.
Representative Petrino.
Thank you, Mr. Chairman. Respectfully, I'm really not concerned with how many calls DCYF gets. I think in every instance we must err on the side of the child. That, I think, is paramount. And for the most part, I think parents make common sense decisions. And most of us know when there is, in fact, neglect, or when parents are just simply letting kids be kids and walk to school and ride their bicycles. I'm sitting here thinking of just one instance that I observed of a mom who basically, in my view, abandoned her child, let the child sit on a sidewalk while she decided to go rollerblading. And I came out of a shop, and I saw this child sitting there crying. And I asked, what's wrong? She said, my mommy's gone. And so I called the police. And after about 10 minutes, here came mom on her rollerblade, just leaving that child on the sidewalk. Clearly, that's abusive. And so the bottom line is this. I think we know when children are neglected and when parents are just being good parents. And whenever there's any doubt, always err with caution on the side of the child.
Representative Raymond.
Well, thank you for your indulgence, Mr. Chairman. Just one final thought on this and the word maturity, because I do think that that is a key here. There are situations where it might be safer for me to expect my 12-year-old to walk to school than for my 15-year-old or 16-year-old, because I know the 12-year-old is motivated and is going to make it to school, whereas my 15 or 16-year-old is going to take the opportunity to skip for the day. So, you know, it's important for us to allow parents to make these kinds of decisions for themselves without saying, well, you know, if the child is old enough by age and old enough by maturity. Well, you may not know that your kid's not mature enough to handle something until you give them that responsibility and they fail to follow through. That's part of like the learning and growing of normal child development. So I hesitate to put exceptions in the neglect law because each child is so unique and each family situation is so unique. And I just, you know, there are some families where you could leave teenagers home for a weekend and it would be fine. They might have a friend over. They're not going to have a raging party. But there are other teenagers the same age who you could not trust to be alone overnight because they're going to make poor decisions. And I think that we need to trust parents to engage in that type of thinking as opposed to asking DCYF or putting in statute what the standards are. I mean, we need to help parents do some of this parenting work. So
Would you then be for the bill or not for the bill?
I'm not for the bill because I think, I mean, as you know, I used to work for DCYF. I went out one summer to a 9-year-old who was home alone while the parents worked full time. They were not scared. They had a big dog. Like, they were totally comfortable. They had a plan, what to do if someone came to the door, what to do if there was a fire, they had it nailed, you know? And I've been out to 15-year-olds who, you know, I wouldn't trust them to watch a goldfish. So it really depends on the individual family and what's going on with that child's development and where they are, you know, mental health wise, and if they're having a good day. There's just so many factors. And I hate to boil it down to like one long sentence that would say that this is okay. And, you know, in all circumstances, if you have a kid who's old enough and mature enough.
We do have another bill coming up. Are we about kicking this one to death, done with, you think? Maybe 20 minutes ago. Call the question. The question before us is House Bill 490, an act relative to modifying the definition of neglect The motion is ITL, moved by Representative Grossman and seconded by Representative Nelson. Would the clerk please call the roll? This is an ITL, so if you are for the bill, you vote no on ITL. If you are against the bill, you vote yes on ITL.
Chairman Pearson.
Against the bill, so. That was mostly for me. Yes on ITL.
Representative Long.
Yes.
I had to compose myself. Representative DeSimone.
Yes.
Representative Bickford.
No.
Representative Nelson.
Yes.
Representative McMahon. Yes. Representative Ball. No. Representative Panic.
Yes.
Representative Seidel.
Yes.
Representative Grossman.
Yes.
Representative Levesque.
Yes.
Representative Petrino will be voting yes. Representative Perez.
See.
Representative Gregg.
Yes.
Representative Moulton.
Yes.
Representative Raymond.
Yes.
ITL passes 14-2.
That can go on consent unless one of the no voters would like to have it debated.
Consent.
So, okay for consent? Okay, Representative Grossman, bitte schreiben Sie. Danke. And either one of the no votes may write a contrary opinion as long as you get it to the clerk.
Has somebody stepped up to do that?
Has
I've
somebody
already done
going-
one.
Representative Bally going to write a negative, a no? Well, he didn't want to. So do you know, it has to be one of the two of you.
I've already done one, so I'm
You don't have
deferring
to.
to you.
Okay. Open the hearing on House Bill 551, an act relative to the Department of Children, Youth, Families, tracking and publishing statistics. The chair calls Representative Corcoran the prime sponsor. The chair now recognizes Vice Chairman Long.
Thank you, Mr. Chairman. I'll like to introduce House Bill 551 FN relative to Department of Children, Youth, and Families tracking and publishing statistics.
Thank you, sir. The chair recognizes our friend Beth Margison from DCYF to speak on the bill.
Thank you very much, Mr. Chair, Vice Chair, and members of the committee. I appreciate the opportunity to speak on this bill. It's to a certain extent, we'd love a website, but some of the information that is being asked to be tracked here, we're not able to track. So we would say that we're probably against the bill. For instance, children who, this is line 3 on page 2, letter L, number and percent of such children who had all their required immunizations by the first day of the school year. That is obviously not information that we could actually track and publish for the public. So, but if you want to give us a website for other things, we'd be happy for that. And we do actually publish statistics. I'm so sorry. It's so hard to see over at this side. We do publish statistics related to our abuse and neglect cases on the Department of Health and Human Services website currently. And we, of course, would always endeavor to make that more user-friendly. So
you do have a lot of data and you publish it?
we do. And it is published.
I have a question. Under Roman numeral 3, if DCYF does and I believe it should be doesn't maintain such a website with at least 99% uptime, the director of DCYF shall be relieved of his or her position, and no division or department of New Hampshire government shall employ, retain, contractor in any capacity of the relieved director. You think that might put a little bit of a chill on hiring at your place?
It might, yes.
Thank you.
It might.
Representative Bickford.
Thank you, Mr. Chairman. Well, that was my question also, and I didn't understand what uptime means. Do you know what it means here?
As we understand it, that it's actually up and available for use.
As opposed to down.
Yeah.
So I think
But I'm
it's
not
wor-
an IT person, so.
I think it's worded reverse of what the person intended.
I think so. I think that they probably meant does not maintain such a website with.
Yeah,
at
I'd hate to
least-
see you
yeah.
get fired for keeping the thing running.
Yes.
You know?
Yes.
Okay.
You know, for the record, I really do like statistics. I chair the New Hampshire Commission for the Deaf and Hard of Hearing. And one of the things that bothers us is there is a pathological fear in the state of actually recording any information. And it makes it very difficult for the deaf community for us to know what we need where. So I do like stats, but what I read in this bill is like stats on speed.
Yes, statistics are
Do you
very
agree?
important. Yes, statistics are important. Data is important, especially when you're talking about the work that we do. It's very, very important. We do publish stats and data. We're always looking to improve things. We did do a fiscal analysis on this bill, and we found that actually getting a vendor to do this kind of website, assuming everything's included, would be about $1 million. And it would probably cost a vendor 3 full-time employees, about a year, keeping it up about $500,000. So, but yes, so that is, the fiscal analysis that we did on it. But yes, we agree. Statistics and data are very important.
Stipulating the purpose of good data is so that one can make good decisions. Do you believe the department presently collects data in a sufficient way as to forward your program in a good way?
We do, but we're always looking for ways to improve. It's a constant improvement. So
So
we get a
this
lot
might-
of hard data and anecdotal data. So
My follow-up is, so there might be a line item or two in this long list that maybe makes a suggestion, maybe we can do that.
yes, we would love to have more money to do data. So.
Any further questions? Sure. What the heck? All right, thank you so much. And with that, I conclude the hearing on House Bill 551. And with that, I open the exec session on the same. And the chair is looking for a motion. Oh, wow. Would you believe that was a tie? Representative Panic, what is your motion?
I motion to ITL.
Thank you. And who would like to second it? Representative Levesque, I saw her hand and we'll remember for the next time. Levesque, bunch of letters we don't pronounce. Okay, good. Thank you. Any further discussion? You do know you get to write the report. Listen, this is your day. You've been off testifying elsewhere and woo-hoo, and you won the tie on this one anyway. And so before you leave tonight, that's all. We're reasonable here. Anybody else want to say anything about the bill that you were all thinking? No? No? Okay. Where's your family from originally, or the Panic family is? You could write it in Polish if you want. You know. Yeah. Okay. All right, I'm killing time to help people who or be too shy now to put their hand up? No, that didn't work. Okay, the motion before us is House Bill 551 ITL, as moved by Representative Panic and seconded by Representative Lavec. Would the chair please, no, that is me. I gotta stop saying that. Would the assistant clerk please call the roll?
Thank you. Chairman Pearson,
Yes.
Vice Chairman Long,
Yes.
Representative DeSimone,
Yes.
Representative Bickford,
Yes.
Representative Nelson.
Yes.
Representative McMahon,
Yes.
Representative Ball, yes. Representative Panic, Representative Seidel,
Yes.
Representative Grossman,
Yes.
Representative Levesque,
Yes.
Representative Petrino,
Yes.
Representative Perez,
Yes.
Representative Gregg,
Yes.
Representative Moulton,
Yes.
Representative Raymond.
Yes.
16 yes, 0 no's. It passes.
Any objection to consent? Seeing none, it's on consent. This ends the exec session on House Bill 551. We will not meet as a committee next week because it is Super Tuesday. The Governor's State of the State address, voting sessions in the House before and after. We will meet 2 weeks from today, and we'll be taking up a bunch of things when I figure out exactly what. I will shoot you an email so you'll have good advanced notice. Representative Long.
So at the chair and vice chair's meeting, there were some committees that were gonna meet during a break. Are we one of those committees?
I hope
that-
not.
Okay, so we're not one of those
On
committees that meet
vacation?
to- Correct.
No, I've been
No, okay,
telling the chair for 6 years now we need to take a break.
okay, great.
And I'm not, no way. You go somewhere for school vacation, okay? Welcome. What's that? What? I am not going to another, I'm not going back to Health and Human Services.
Thank you.
I mean, I liked it, but I just thought it needed cleaning up, so maybe try. Manchester.
I'll give you a call tomorrow. Sure. Yeah. Thanks so much. Yeah. Yeah, you email me. Okay. Donated the next. Oh, no, 50 cents. When did you see the
I can pay with a credit card. Okay, but I didn't know that. So I sent for a card for $20. And when I used it, I realized it said, oh, and if you use Kids on the street, I just use the Kids. Okay. Not the I can, that's I won't be the cross. It's just for well, you know, I'm sorry. Yeah, me too.